00421, electronic application of Kentucky Power Company for approval of affiliate agreements related to the Mitchell Generating Station. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission. With me today is Vice Chair Amy Cubbage. For those in the hearing room, please set your cellular phones to silent mode or turn them off. Disinfecting wipes have been placed at the witness table. We ask that as each witness ends their testimony and leaves the witness stand, that they wipe down the area. For those witnesses, I guess they're not here, so there's no point in going over this. I'll just ask Mr. Vaughn if he'll make sure he's connected, and he'll let us know if he has issues connecting. The hearing today is for the purpose of taking evidence on the proposed Mitchell ownership agreement and Mitchell operating and maintenance agreement. At this time, we'll have an interior appearance of counsel for the applicant.
On behalf of Kentucky Power, Katie Glass and Mark Overstreet with the law firm of Stites & Harbison, 421 West Main Street, Frankfort, Kentucky, 40601. Also appearing pro hoc vice on behalf of Kentucky Power are Kristen Blend, Hector Garcia Santana, and John Crespo.
Thank you. Before we move to the AG's office, can we turn the speakers down just for a minute? Thank you, Ms. Glass. We'll see if that's any better with feedback. For the Attorney General's office.
Mike West for the Attorney General's office. John Horn is present as well. We have Larry Cook on virtually, and our witness Lane Collin is present as well.
Thank you. And for the Kentucky Industrial Utility customers.
Morning, Honors. Mike Kurtz, Jody Kyler Cohn for KIUC.
Mr. Bain will not be with us today?
Correct.
Is that correct?
Yes.
All right. And for Commission staff?
Nancy Vinsel for Commission staff, and I have with me today John Robness and Mary Whitaker from our financial analysis staff.
All right, thank you. Ms. Glass, it's my understanding that on Friday, that Kentucky Power filed evidence of notice of this hearing. Is that correct?
That's correct, Your Honor, yes.
And were there any issues with notice?
No.
And other than, I think there are some outstanding petitions for confidentiality, are there any other motions outstanding?
No, Your Honor, and I'm not aware of any outstanding petitions for confidentiality.
Okay, all right. And do we need to take anything up before we begin with the witnesses this morning?
Sure. This morning, Your Honor, the Kentucky Power Company filed a supplemental response to KPSC 2-3, along with a supplemental spreadsheet correcting an error. That will be addressed by company witness Steve Haynes.
All right. Thank you.
Thank you.
All right. So we've had for a day and a half now on our website a message similar in accordance with the public notice that Kentucky Power has filed that anyone interested in providing public comments may do so by signing up ahead of time. As of about 15 minutes ago, 20 minutes ago, nobody has signed up to provide public comments. So for the benefit of anybody that's viewing this that would like to provide written comments to the Public Service Commission on this case, you can do so by emailing those to psc.comments. Is it comment or comment?
I think it's just comment.
Comment. psc.comment, COMMENT @ky.gov. We ask that any comment that you provide include your name, your address, and the case number, which in this matter is 2021-00421. You can also mail public comments to the Public Service Commission anytime before submission of the case. You can mail those to 211 Sauer Boulevard, Frankfort, Kentucky 40601. And again, just include your name, your address, and the case number 2021-00421. If there's nothing else, Ms. Glass, would you call your first witness?
Yes, Your Honor. The company calls Timothy C. Kearns.
Okay. Mr. Kearns, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Timothy Kearns. My address is 2791 North US Highway 231, Rockport, Indiana, 47635.
Ms. Glass, you may ask.
Thank you. Mr. Kearns, can you state the name of your employer, please?
I'm employed by the American Electric Power Service Corporation. I'm sorry, can you hear me okay?
I can.
Okay, thank you.
And can you state your position, please?
I'm the Vice President of Generating Assets for Indiana, Michigan, and Kentucky Power.
And did you cause to be filed into the record of this case testimony and responses to data requests?
Yes, I did.
Do you have any changes or updates to your testimony or data request responses?
Yes, I do. I have one.
Okay.
My response to data request AG-K IUC 127, I included a table for the remaining estimated direct costs for the CCR project at Mitchell, and that table, those dollars are represented in thousands of dollars. I didn't include that. There's no marking there that indicates that.
All right, thank you. Do you have any other changes or updates?
No, I don't.
And with the exception of that one change that we've discussed, if I were to ask you those same questions today, would your answers be the same?
Yes, they would.
Thank you. The witness is available for cross-examination.
Mr. West?
I think we had discussed an order for.
Oh, yeah, excuse me. We did. I'm sorry to cut you
That's
off, but efficiency.
Yes.
Sorry to cut you off. So we did discuss, it's my understanding, there is no objection to an amended process of cross-examination. Is that right, Ms. Glass?
No, there's not.
Okay. Ms. Vincent, any questions?
Yes, I do. Thank you, Chairman. Good morning, Mr. Kearns.
Good morning.
If you have any problems hearing me or you don't understand the question, please let me know.
Thank you.
In one of the response to one of the data requests, you provided a list of all of the permits that have to be transferred from the name of Kentucky Power to Wheeling Power.
Yes.
To follow up on that, have any permits been transferred from Kentucky Power to Wheeling Power yet?
At this time, no.
And I want to follow up on another one of your responses to a data request. And with the chairman's permission, may I approach the witness?
Sure, please. Thank you.
And Ms. Whitaker is passing out, Mr. Kearns, your response to the commission's first request, item 8. And staff would like to introduce this as Staff Exhibit 1. And in this question, you were asked about the ELG upgrade capital expenditures. Can I give you a minute to please read through your response and let me know when you're done?
Okay.
Thank you. In that last sentence where you say, thus the determination of the amount of ELG upgrade, operations, maintenance, and other expenses will be based on a review of accounting records whose work orders list ELG upgrade equipment. Could you expand upon that and explain what you mean there?
Sure. So we've currently employed a technical expert, Burns McDonald, to review the ELG and CCR, the scope of work that'll be required to comply with those two rules. We expect that from that technical expert, we'll get a breakdown of which costs are associated with CCR compliance and which costs would be associated with ELG compliance. And then we'll capture those costs on work orders in our existing work management and work order system, and those costs would be allocated accordingly.
And as I'm sure you're aware, with the Commission's July 15th, 2021 order In 2021-00004, the commission found that Kentucky Power did not meet its burden of proof to, and then the commission declined to approve a CPCN for the ELG, but did for the CCR. So under what circumstances would Kentucky Power be allocated ELG upgrade O&M costs?
I don't believe there would be a circumstance where they would, not for the cost of ELG compliance.
So not for any capital expense or any O&M expense?
That's correct. No capital or O&M associated with the ELG compliance.
Staff has no further questions for Mr. Kearns.
Mr. West?
No questions for this witness.
Mr. Kurtz?
I do a little bit, thank you, Your Honor. Good morning, Mr. Kearns.
Good morning.
You are in charge of the Mitchell Generating Unit, the maintenance and the running of the plant?
Yes, sir.
Okay. Are you generally familiar with the company's alternative buyout proposal where Wheeling would potentially take one of the Mitchell units and Kentucky Power would take the other Mitchell unit?
Yes, generally I am.
Okay. I'd like to ask you to look at an exhibit. You're aware that every year the company files a Mitchell report with the commission about the prior year's operation?
Yes.
Ask this marked as, I guess, KIUC AG or just KIUC?
So y'all have a choice on this, and Ms. Glass and Mr. Overstreet haven't objected yet. And I'll just tell you my perspective before I ask for a position. I think there's a distinction between intervening and participating jointly versus jointly sponsoring a single witness's testimony. And for that purpose is why I asked Mr. West and Mr. Kurtz individually if they had questions, because they can have their own case they'd like, even though they're jointly supporting individual testimony. So for that purpose, I would mark this as KIUC hearing exhibit 1 if there is no objection from the company.
No.
No, Your Honor.
Thank you. Is it Vice?
Thank you.
Sorry. Okay, so this will be marked as KIUC Hearing Exhibit 1. I'd like to ask you some questions about, do you recognize this as being part of the package that the company files with the commission annually? If you turn to page 2 of the exhibit, you'll see the case number at the top that was. In fact, I think the most recent one was filed yesterday.
Yes, I'm sorry. Could you repeat the question, please?
Do you recognize this as being part of the company's annual filing with the commission?
Yes, I do.
Okay. Let me just ask you, forced outage rate at the top, that's the percent of the hours of the month or year that the plant, that the unit is not able to operate because of an unplanned forced outage?
Yes, or curtailment. Or a curtailment that maybe doesn't force the unit out, a piece of equipment being out of service that limits the unit to get to full capacity, but yes.
As opposed to a planned outage or planned maintenance, which is, of course, planned.
That's correct.
Okay. And the second column, equivalent forced outage rate, is a derivative of the forced outage rate?
Yes.
Okay. The equivalent availability factor is the percent of hours of the month or year that the unit is available to produce electricity.
Yes, that's correct.
The net capacity factor is the actual percent of the hours of the year that the unit produced electricity. Is that correct?
Not necessarily, no. The capacity factor is the percent of the rated output that the unit generated.
Okay. And then the heat rate is the efficiency at which the unit converts coal to electricity, correct?
Yes, that's correct.
And the lower the heat rate, the better?
Yes.
So at the top of this document, we have Mitchell Unit 1. I just want to go to the January through December totals. It was forced out 43.9% of the hours of the year in 2021,
Yes, that's correct.
as opposed to Unit 2, which had a forced outage rate of only 6.91% during 2021.
Yes, that's correct.
So just based on this very simple metric and this one data point, would it be fair to say that Unit 2 was more reliable in 2021 than Unit 1?
No, I don't believe I would characterize it that way. I would, as you stated, characterize the forced outage rate of Unit 1 was greater than Unit 2. As you can see in the months of March and April and May, for Unit 1, the forced outage rate was extremely high, and that was due to a GSU transformer failure on Unit 1, and so that's the amount of time that the unit was out of service to replace that transformer. I think if you look back through all 5 years' worth of data here, you'll see that that forced outage rate swings back and forth, as does the heat rate and as does the availability, to say that there's essentially no difference in the performance or no material difference in the performance of the two units sans this major event.
Okay.
Mike, can I ask you, Mr. Hertz, sorry, didn't mean to address you so informally. I'm not seeing identifying information on the first sheet of this as I am the second.
Yeah, it came in yesterday, and I guess it just wasn't marked. Yeah, this is just the way Kentucky Power filed it.
Okay, so this is what was filed with the annual operating report that was filed yesterday?
Yes.
Understood, thank you.
Okay, well, so for 2021, just to recap, Mitchell Unit 1 was forced out 43.9% of the hours of the year versus Unit 2, 6.91%. Is that correct?
Yes, that's correct.
Okay. And the capacity factor for Unit 1 was 26.39% versus a capacity factor of 43.19% for Unit 2.
Yes.
Correct.
Yes.
And Unit 2 had a better heat rate in 2021, meaning it was more efficient.
Yes.
Let's turn the page to the 2020 data. We see that Mitchell 1 had a 16.66% forced outage rate versus 9.89% for Unit 2.
Yes.
The capacity factor for Unit 1 was 22.43% versus 30.2% for Unit 2.
Yes, sir.
Okay, and the heat rate in 2020 on Unit 2 was better than the heat rate for Unit 1, correct?
Yes, that's correct.
Turning to page 2019 data, the forced outage rate for Unit 1 was 12.14%, is that correct?
Yes, that's correct.
And Unit 2 had only a 2.81% forced outage rate, meaning it was forced out very, very, very little, very, very few hours of the year in 2019, correct?
Yes, that's correct.
Okay. The capacity factor was fairly close in 2019. I had this question for an anomaly, or this is a question, Mr. Kearns. Do you see the heat rate in February for Unit 1? How could the heat rate be 5235, 5,235, when, you know, these coal units are generally more in the 10.2, 10.5 kind of range?
Yeah, so I can't speak to the exact reason for, you know, the February data. You ask how that can happen, though. Generally speaking, it can happen based on the timing of outages and based on when you empty the coal silos. So you're not refilling those silos if you're coming down for an outage, so it looks like you were incredibly efficient. You had generation, but no coal going into the silos. Similarly, again, depending on when the units come back from an outage, you fill the silos but don't have any generation, the heat rate looks really bad. So looking at it on a month-to-month basis on either side of outages can be tricky, but I don't have an answer for that right now.
Okay, that's a good explanation. The heat rate for Unit 1 in 2019 was better than the heat rate for Unit 2, 9,700 versus 10,176, correct?
Yes, that's correct.
Let's turn to 2018. Again, we see the forced outage rate for Unit 1 being essentially 3 times higher than Unit 2, correct?
Yes, that's correct.
Okay. Capacity factor for Unit 1 was slightly worse than Unit 2, correct?
That's correct.
And the heat rates look like they were pretty much equivalent in 2018, with 10.4.
Yes.
Okay. Final page of this. The forced outage rate in 2017 for Unit 1 was 23.85%, correct?
Yes, that's correct.
And for Unit 2, 1.96%.
Yes.
That's a fairly considerable difference, isn't it?
It is, and again, I would point to February and March of 17 on the forced outage rate. We had a low-pressure turbine failure where we threw a blade and actually that unit was out of service. So again, sans these large events and unexpected events, the forced outage rates are far closer than what 2021 and 2017 numbers would have you believe.
If there was a PJM capacity performance event when one of the units was down, then it would be subject to capacity performance penalties?
My understanding is that it could be, but I'm not the capacity performance expert, so I'm going on my understanding.
Okay. So, and of course, that would be a higher risk. So, let me start with a new question. Would you agree that for the 5 years here, the most recent 5 years, the forced outage rate for Unit 1 was consistently higher than Unit 2?
Yes, the data would show that if you average those 5 years, Unit 1 would be higher.
If a unit is forced out quite often, does it, versus a unit that's forced out rarely, would that result in higher maintenance costs for the unit that's forced out more frequently?
I would say potentially. I mean, you certainly have more corrective maintenance, but if you're doing, there's a thought that you can try to fund the maintenance on a unit for 100% availability and 0% forced outage rate, and I would argue that that would cost you more in O&M than responding to the forced outages in some cases.
Right, I see that. If you were choosing, based upon this 5 years of data, which of these two Mitchell units, if you were going to own one versus the other, which one would you choose?
I would say I would choose either. And I base that on the fact of the knowledge of the two units and the causes of the forced outages and the repairs that have been made, say, to Unit 1 up to this point that address some of those liabilities, such as cooling tower repairs and precipitator repairs that have been historically our bad performers. We have in the forecast for 2023 similar repairs to Unit 2 because we're seeing more of those curtailments and those nagging liabilities, and so we'll be replacing things like air heater baskets, cooling tower hot deck, and precipitator internals to improve that forced outage rate. So My point here is that we don't maintain we don't give preferential treatment to either unit in the way that we operate, maintain, or our philosophy around that. It's just the equipment has different, run hours in some cases, or has reached the end of its useful life at different times. And so we address that, ahead of time, or when we have chance.
Why is the heat rate on Unit 2 consistently better than Unit 1, except for that one anomaly year?
I would argue that it's anywhere from 300 to 500 BTUs difference, depending on the condition of equipment. Like I mentioned, the cooling tower. If the cooling tower, if it's time to replace the fill, or we have issues with the spray header nozzles or something like that, that can impact the heat rate that much. Operating at a reduced capacity factor, if you're in a time when the market is soft and you're running the unit at a lower output, the unit is typically less efficient at that point. So there's nothing about the design of one unit over the other that makes it significantly different in its heat rate. It's more equipment condition driving that.
Okay. Based upon what you know about PGM capacity performance risk, is it riskier to have all your eggs in one basket, so to speak, one unit versus a diversified portfolio? So in other words, if you have one big unit and it's down during a capacity performance event, the exposure would be higher than if you had multiple units.
It seems like, again, I'm not the capacity performance, expert. I might throw you to Witness Vaughn to give you a better answer on that, but I can agree that potentially the exposure, it seems like it could be greater. But.
Thank you, Mr. Kearns. No more questions, Your Honor.
Any questions?
Yeah, just a couple. Good morning, sir.
Hey, good morning.
Pretty good. How are you?
I'm well.
Just so I understand what's going on currently with Mitchell 1 and Mitchell 2 as far as the CCR and ELG upgrades. Have the CCR upgrades commenced on both units?
The CCR work has commenced on the ponds, on the removing CCR material and what have you. Yes.
So it would support both units?
Yes, there's also a component, there's, a dry bottom ash conversion. Part of that will be toward the CCR compliance. That hasn't started. So when you say on both units, there's nothing on the individual units yet. It all has been in the pond work.
Okay. And would that be the same for ELG?
Nothing except engineering and design has commenced on ELG. We've released the consultants to do the E&D work, but no physical construction or anything like that.
Okay, that's all I've got. Thank you.
Thank you.
Mr. Kearns, a couple of questions. How many generators do you oversee in the position?
Total number of physical generators or plants in the
So
facilities.
EGUs, yeah, individual units.
6, 11, 12, 13, 14, 15, 16.
Okay. So Rockport units, are both of those under supervision?
They are.
Okay. And then Big Sandy 1
Big Sandy Unit 1, yes, sir.
and Mitchell 1 and 2?
Yes, sir.
And so do you oversee other units owned by other affiliates of AEPSC, is that right?
I have 5 solar sites and 6 hydros in I&M.
Okay, so in terms of thermal units, the Rockport 1 and 2, Mitchell 1 and 2, and Big Sandy 2 are it?
Big Sandy 1.
Big
yes.
Sandy 1, excuse me.
Those are
I'm
the
sorry.
5, yes.
Okay. And did you previously have supervision over Big Sandy 2, or was it retired before you moved into this kind of position?
It had retired.
Okay. Of those 5 units, those 5 thermal units, do any of them have equivalent forced outage rates as Mitchell Unit 1?
Rockport Unit 1 was high. Without having the number in front of me, I won't tell you that it's higher or as high as. And again, are you asking about the 5-year average or a
Yeah, the
particular
last
year?
couple of years. And I after I asked it, that was my thought, is that I should give you some sort of time frame as reference. Not just last year, but over the last few years. Have any of the forced outage rates been in the neighborhood of Mitchell Unit
Not as high as Unit 1, but within a few percentage points.
Is equivalent forced outage rate, is that the synonymous with E4D, the technical term?
It can be. E4D, I think, is a rolling 12-month average of the forced outage rate, and it enters into the UCAP calculation. What we have here is just E4D for the calendar 12, or the E4 for the calendar 12 months.
Yeah, so I'm glad you're able to, so Mr. Kurtz was asking you about performance assessment intervals and penalties. You said that's not your sort of wheelhouse, but UCAP is kind of your wheelhouse, right?
I understand what UCAP is, and yes.
And that when AEP is coming up with their FRR plan, the amount of generation it has available, the amount of capacity it has available is on a UCAP basis for PJM purposes. Is that your understanding?
That's my understanding.
Okay, and so if there's more generation, then Kentucky Power has an ability to monetize that generation in excess of what's needed for their FRR plan. Is that your understanding?
Now you're getting out on the fringe of my understanding. Again, I believe Mr. Vaughn would be better at answering that, but
I guess what the question I want to ask you is, the higher the forced outage rate, the higher the E4D might be, the lower the UCAP calculation is. Is that right?
that's my understanding, yes.
All right, thank you, Mr. Kurtz. Do you have any redirect, Ms. Glass?
No, I don't.
Okay. Is there any reason that Mr. Kurtz can't be excused for the remainder of the hearing?
No, staff would like to move into the record, staff hearing Exhibit 1.
Is there any objection, Ms. Glass, to staff hearing Exhibit 1?
No.
All right.
Chairman, I
Enter staff hearing Exhibit 1. Mr. Kurtz?
thank you. I move for the admission of KIUC hearing Exhibit 1.
Ms. Glass?
No
Any
objection.
And the same for KIUC hearing Exhibit 1. All right, thank you, Mr. Kurtz.
Thank you.
All right, Ms. Glass, you may call your next witness.
Kentucky Power calls Brett Madison.
Who will be working with Mr. Madison?
I will, Your Honor.
Okay. All right, Mr. Madison, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
All right, please have a seat. State your name and address for the record.
Name is Brett Madison, President and COO of Kentucky Power, 1645 Winchester Avenue, Ashland, Kentucky.
No.
I'm losing my mind. Did I swear you in? I
Yes, you
apologize.
did.
Okay, all right.
I guess I'm losing mine too.
Yeah,
I'll do it,
it's-
I'll do it again if you'd
No,
like.
that's okay. I asked you something before you sit down. I assume it wasn't where you get your suit, so, I assumed it was, so I apologize for that. Ms. Blend, you may ask.
Thank you, Your Honor. Good morning, Mr. Madison. Will you please identify by whom you're employed and in what position?
Kentucky Power President and Chief Operating Officer.
Thank you. Did you cause direct testimony and responses to data requests to be filed in this case?
Yes, I did.
Do you have any changes or corrections to any of those responses at this time?
No, I do not.
And if I were to ask you the questions contained in those documents today, would your answers be the same?
Yes, they would.
Thank you. Your Honor, Mr. Madison is available for cross-examination.
Ms. Hensel?
Yes. Good morning, Mr. Madison.
Good morning.
So this to all the witnesses. If you can't hear me, please let me know. If you don't understand a question, I request you will let me know also.
Yes.
Do you have a copy of the proposed ownership agreement handy?
Yes, I do.
And for your reference, I'll say it again while you bring it up. The proposed ownership agreement was filed as Exhibit 3 to your direct testimony. Is that correct?
I believe that's correct.
And I'm going to have you turn to, it's actually Article 9.6B, and it's page 18 of 34 of that exhibit.
Could I ask you, is that Exhibit 2 or is that Exhibit?
Exhibit 3,
It's 3?
Which page?
18 of 34.
I'm sorry, was it 2 or 3?
3.
3. Okay, I'm there.
Okay. And this particular provision is addressing the appraisal process. To start with, have appraisers been determined yet or appointed?
No, they have not.
Okay. What I'm going to ask about is the very last sentence of this. If I can have you read that just to yourself and let me know when you're done.
Is it the very last sentence of the paragraph in the middle of the page?
Yes, it begins, if the fair market value determined by one of the 3 appraisers.
Okay.
What I'm asking about here is where it says, if the fair market value determined by one of the 3 appraisers deviates from the fair market value determination of the middle appraiser by more than twice the amount by which the fair market value determination of the other appraiser deviates from the fair market value determination of the middle appraiser, then the fair market value determination of such appraiser shall be excluded. And from the wording of this, it appears that, I'm going to call it the outlier appraisal, if it were to exist, is excluded only if it is higher than.
I don't believe that's the intent of this language. The intent is if you have an outlier that's according to what it said, twice, one way or the other, up or down. It's not just one side or the other. You would throw that one out.
Okay, so the intent is that that outlier be either higher than or lower than by twice the amount.
Correct.
Would you agree that this language needs to be, again, I'm not asking you for I'm not asking you for a legal opinion. Would you agree that from this reading and what you say the intent is, that the language of this section should be revised to reflect higher or lower?
I think the intent is there, and it may need to be reviewed by, legal counsel to clear it up and make it a little bit clearer.
And I would also note, in the next section, Article 9.6C, which discusses establishing the decommissioning costs. It has similar language that seems to imply that only a higher outlier would be excluded. And I just want to confirm that the intent here was that it be the higher or lower.
The intent is the outlier either way.
In the ownership agreement, in Article 12.2,
Are we talking about the current ownership agreement or the proposed?
the proposed, I didn't know there was a current ownership agreement. I thought the current agreement was only for an operating agreement.
That's correct.
Okay. Yes, the proposed ownership
Okay.
agreement, Article 12.2. And this addresses dispute resolution.
Yes.
And as currently written, a dispute between operating committee members is submitted to senior executive officers with the authority to resolve such disputes. I'd like to take a step back and confirm that the Mitchell Operating Committee consists of 3 members: you as president of Kentucky Power, the president of Wheeling Power, and then Mr. Kearns as a non-voting member representing AEP-SC. Is that correct?
That is correct.
And I believe in one of the data responses, and I believe it was in this case, Kentucky Power was asked who the senior executives were that the dispute would be turned over to for resolution. And as I recall, the answer was the dispute would be turned over to you and the president of Wheeling Power. So my question is, if there is a dispute between the operating committee members, is the dispute submitted to you, to the president of Kentucky Power and the president of Wheeling Power?
To the operating committee, yes.
And if the operating committee members have a dispute that they can't resolve, and the dispute is turned over to senior executives with the authority to resolve the dispute, who are those senior executives?
I'm not exactly sure who those senior executives would be. It could be the executive vice president of generation and the chief operating officer
Of Kentucky Power?
of AEP.
Of AEP? I ask because it's unclear who these officers might be. And I would note that as opposed to a technical dispute, which has a pretty substantial dispute resolution provision, this does not. At this point, it's not clear if it's circular logic or who the dispute would be sent over to. So what I'm asking you is, as someone who participated in negotiating this agreement, who did you envision the senior executives would be?
Well, the operating committee is made up of the two senior executives that you mentioned.
Right, and I'm speaking about a dispute
Right.
resolution between the operating committee.
And beyond that, I'm not sure at this time who those names would be.
Okay, that is a fair enough answer. In one of, a response to, it was actually to the AGKIUC's first request, item 19, you responsored that response, and you discussed using the fair market value as a valuation point for the buyout price. One of your comments was that the fair market value created a neutral benchmark to use to establish a valuation. So I would ask, was there any consideration given to putting Kentucky Power's interest in Mitchell up for sale and allowing Wheeling Power and any other interested buyers to actually put in a bid on that interest?
Not to any other interested bidders, but as a provision beyond fair market value, there was a backstop provision that was put in 9.6 that witness Steve Haynes can give a lot more detail than I can, but there could be an agreed upon price between Wheeling and Kentucky Power. Of course, it'd have to be approved by this commission on that price. For the transfer of those units. And as the backstop of that, there also could be where Kentucky Power owned one unit and Wheeling owned one unit. But as I said, witness Steve Haynes can get into a lot more depth in the mechanics of that.
Okay, thank you. Does the valuation process for the buyout price give any credit to Kentucky Power for Kentucky Power's share of the CCR compliance project that was approved by this commission in case number 2021-00004.
Yes, I believe it would, because the CCR work that would be done would be rolled into the total value of the plant. So Kentucky Power would be entitled to their portion of that.
And there was at least one data response that seemed to indicate that there could be a negative valuation for the CCR. Do you recall that?
I'm not recalling that, but it could happen possibly. And again, I think witness Haynes could probably answer more detail in that.
Okay, thank you. I'll save this one for Mr. Haynes. So in regard to decommissioning costs, at the time of sale, what actions, if any, will Wheeling Power take to fund its share of the decommissioning costs?
What actions would Wheeling take?
Yes.
Again, I think that the mechanics of that decommissioning, witness Haynes could give a lot more detail to that than I can in that regard.
Okay, I'll save those questions for Mr. Haynes
Okay.
also. Would you agree that as defined in the ownership agreement that the CapEx capital expenditures adjustment includes ELG costs as an adjustment?
I'm not sure that I would agree with that, and I hate to keep pitching things to Mr. Haynes, but he's the expert on that.
Okay, let me, I will send that to Mr. Haynes, but I do have a response to a data request that you filed. Let me pull this up so I can make sure I give the right citation to council. This is a response to staff's first request, item 16, and again, it's an Excel file. This was filed on December 22nd, 2021. And this is labeled as KPCO underline, I'm just going to get to the end, 1 underline 16 underline attachment 1 XLSX. Do you have access to that?
Is it KPSC 1-16? Is that,
Yes.
does it start, let's see, including ELG, capital expenditures, extent funded by Wheeling? Is that in the top?
Let's see here. This is an Excel file.
I don't have the Excel file.
Okay, well then I'm just going to cut to the chase here. In this Excel file, which is part of a data response that you sponsored, there are, let's see here. This includes an account for ELG compliance broken out between Kentucky Power and Wheeling Power. Council, would you like me to wait until you can get access to this?
Thank you, Ms. Winslow. I was just going to suggest we may be able to provide an electronic version to Mr. Madison. so he
Okay,
can review it.
I will wait. I will tell you, I wanted to print this out, but to get it on the right size page was not going to work.
Yeah.
And I'm not going to make you read something teeny tiny.
Thank you.
May I
Thank
approach
you.
the witness?
Yes. Okay.
Okay.
Okay. As you can see, it consists of basically two tables, but the first where it says, it starts in column A, row 3, 117 Kentucky Power Company hyphen Gene. And then the next column B is the project, and I'm just going to, again, cut to the chase, MLUO ELG compliance. When you look at row 10, column H, it's showing a total of ELG compliance, and I'm guessing allocated to Kentucky Power, $1.458 million. Do you see that?
Well, this isn't broken down like you described it with row 10 and column H. I don't see that on here.
It may be displaying differently on my iPad.
Okay.
Would it be easier if he had this printout?
Yes.
Ms. Glass, can I ask?
Absolutely.
Oops. That's a printed version of the document.
This, because the columns may not be numbered, this is on a line that says Kentucky Power Company Gene, Gene total.
Does it have 117 out to the left of it?
Yes.
Okay.
Do you see the line where there's one, gonna have to blow this up. $1,458,283.36.
I do see that.
Can you tell us what these ELG costs are for?
Well, if I'm not mistaken, I think those were costs that we had incurred whenever we filed for the CPCN, that we had incurred on ELG costs with pre-engineering and those type things that was denied.
And these costs these continue to be allocated to Kentucky Power through 2021. It says year-to-date through November 2021. So does Kentucky Power continue to be allocated costs for ELG? For the ELG project?
Not that I'm aware of.
Is there any of the witnesses that could describe what these costs consist of?
I think witness Vaughn should be able to do that.
Okay. I'll follow up with him.
If I may, Ms. Vinsel,
Yes.
I'll submit, I think Mr. Kearns may be better able to testify regarding the costs that have been incurred to date regarding ELG.
Okay.
Well, is it permissible to recall Mr. Kearns to get an answer to this?
Are you asking me, or are you?
I'm actually asking Chairman you,
Yeah.
but also,
Mr. Kearns hasn't made his escape yet, so I would just ask him to stick around.
We have no objection to him being
You can recall
recalled
him.
regarding this topic. Thank you, Your Honor.
I had to check before I said that, but he's still back there watching, so we'll recall Mr. Kearns then.
I just have one more item, and it's not a question. Staff will be issuing a post-hearing data request, and I believe you know the drill now. Staff will issue a written post-hearing data request after the hearing. What we would like to get are AEPSC's Mitchell-specific costs that are allocated to Kentucky Power that will no longer be allocated to Kentucky Power if the commission approves Liberty Utilities Company's request to acquire Kentucky Power.
Okay, well,
So, yeah, basically, what we're going to be asking for are the cost allocated to Kentucky Power related to Mitchell that are going to have to be mitigated somehow.
we can do that.
Staff has nothing further for Mr. Madison.
Mr. West?
I believe Mr. Kurtz was going next. I can go, but I think the order we had talked about was KUC, then AG, but.
Oh, I just knew there,
All right.
here, and here, there. So,
I can go first.
if you'd like to go first, I have no problem with that, Mr. Kurtz.
Chairman, no questions.
Mr. West?
Just a few. Mr. Madison, do you have your testimony available to you?
Yes, I do.
Okay. Can you turn to page 8?
I'm there.
Okay. On page 8, you excerpt a portion of the commission's order from October 8th, 2021, do you not?
Yes, it is.
Can you read that for us?
Sure. It says the commission expects Kentucky Power and Wheeling Power to promptly seek modifications to the Mitchell operating agreement should Wheeling move forward with the ELG project, in particular, the provisions designating Kentucky Power the operator of Mitchell and assigning it certain responsibilities in that role. The commission further expects Kentucky Power and Wheeling to promptly seek modifications of environmental permits related to ELG currently held in Kentucky Power's name. These modifications will be necessary to ensure Kentucky Power's representations that neither it nor its customers will bear any of the cost of Wheeling's ELG project.
Can you identify anywhere in that statement where the commission required Kentucky Power to create an ownership agreement that defines the terms of the transfer of Kentucky Power's interest in Mitchell?
Well, in order to change the operator and to fulfill what the commission was seeking there, we needed to change the operating agreement, and this is what necessitated that.
I'm specifically talking about the ownership agreement that governs how Kentucky Power's interest in Mitchell will be transferred in future years. Is there any requirement in that statement that requires Kentucky Power to make an amendment to that effect?
I don't think it particularly spells it out, but it was inherent in that to us.
Can you explain how it was inherent to you?
Well, when we changed the operating agreement, then the transfer needed to occur as well because we had to get out of the plant based on the ruling that was done at that time that we will do CCR only. And it was, as I remember and recall, it was case 1 and case 2. Case 1 was ELG and CCR. Case 2 was CCR only and be out of the plant by December the 31st, 2028.
So it was an inference on the part of Kentucky Power as opposed to any explicit statement in the order. Is that fair to say?
I wouldn't necessarily agree with that.
Okay, so where's the explicit statement that Kentucky Power should create an ownership?
It's not in that paragraph.
Is it somewhere else in the order from October 8th?
No,
Is it in a different order?
no.
So where is it?
It's not in an order.
I thought you just said it was expressed somewhere.
I said it was inherent.
So AEP has requested approval for Kentucky Power to be transferred to Liberty in case number 2021-481, correct?
Yes.
Okay. Given that proposed transfer, what financial incentive does AEP have to ensure that Kentucky Power is treated fairly by the operation of the proposed operating and ownership agreements?
Could you repeat that question?
Given that proposed transfer with Liberty, what financial incentives does AEP have to ensure that Kentucky Power is treated fairly by operation of the proposed operating and ownership agreements?
Well, currently that Mitchell plant is owned by Kentucky Power. Of course, AEP owns Kentucky Power, and we want to ensure that there's a seamless, fair, and reasonable transaction with Mitchell among the parties because Kentucky Power owns a 50% undivided interest in it, as does Wheeling. So the financial incentives, I'm not sure exactly what you mean by that.
Well, isn't it reasonable to assume that AEP would have a greater incentive to protect the long-term financial health of a company it plans to own long-term, to the detriment of the financial health of a company it does not plan to own long-term?
I think that it's AEP's best interest to do that irregardless.
To do that, meaning to do what?
To protect the financial interest of the Mitchell operating facility.
On behalf of Wheeling Power or on behalf of Kentucky Power?
On behalf of both. We have a 50% undivided interest in the Mitchell plant. Kentucky Power does, and Wheeling, as it exists today.
Is it reasonable to assume that an AEP shareholder would prefer that AEP prioritize the financial health of an asset it plans to hold on to over the long term, over one that it plans to transfer imminently?
I'm sorry, could you repeat that? I didn't hear you well.
Is it reasonable to assume that an AEP shareholder would prefer that AEP prioritize the financial health of an asset it plans to hold on to over the long term over one that it hopes to transfer imminently?
I think it would be the same whether it's short-term or long-term. You want to ensure the financial health of the asset.
Given that the bargaining power of Kentucky Power and Wheeling Power are inherently unequal in the AEP system at this time, why should the commission approve any request on behalf of AEP through Kentucky Power to approve or reject these proposed agreements?
Oh, I think that's a wrong inference that it's unequal.
Explain your reasoning.
Well, because we each own 50% of the Mitchell plant, undivided interest equally today. So one doesn't have an advantage over the other.
But under the proposed transfer, that won't be the case next year if the transfer is approved, correct?
I disagree with that.
In what way do you disagree with that?
I don't think one's advantaged over the other.
Okay, I think I've made my point. That's all the questions I have.
Vice Chair?
Yeah, I do have some questions. Good morning, Mr.
Good morning.
Mason. I want to take a step back, big picture. And I'm right, you're on the operating committee currently on behalf of Kentucky Power. As that representative, can you explain to me how the two agreements that we're being asked to approve came to be, how they were negotiated?
Sure. What we did is we looked at the order that came out with CCR only, so the interest of the two companies have changed based on the ruling of this commission and the West Virginia Commission, because the West Virginia Commission approved both, which feasibly could carry the plant through operation of 2040. And for Kentucky Power's interest, it would cease at 2028.
Real quick, who do you mean by we?
Well, the operating committee is what I'm talking
Okay,
about.
that's what I wanted to clarify,
Right,
to make
right.
sure we were still talking about the operating committee and not other parts of it.
No, the operating committee saw that. So the paragraph that I read earlier to the representative from the AG's office showed that we needed to change the operator within the agreement. And so we began to do that. It needed to move to Wheeling, knowing that when Case 2 was approved, we would be out of the operating of the plant in December the 31st of 2028. That was a fundamental change as well. So we began to make proposals, and then there were operating committee meetings with seeking legal counsel along the way, and that's how we kind of developed the proposals that we have before you today. And myself and the president of Wheeling Power, and then witness Tim Kearns, served in a non-voting capacity on that committee.
So would it be fair to say the three of you were the principal architects of the terms that we have in front of us?
We provided overview and oversight of the development of that.
Okay. Who else was involved besides the three of you?
There were APSC, others that were involved, legal counsel, internal legal counsel, and some individuals from the regulatory business function within AEPSC.
Without getting into any legal advice, where did the decommissioning, not the decommissioning, where did the sale provision come from?
Well, it's one that we created as an option to have the fair and equal treatment of the operating plant if we're not going to be in it in 2028. And it's my understanding that, Wheeling Power, I think, will have the option, if they're going to carry it through 2040, what we needed to do at that time with the operating plant. One of the options was that we could transfer our interest to Wheeling, and an agreed upon price, of course, approved by this commission, would be one way for us to get our interest out and to be treated fairly for all, Kentucky Power customers.
Did the committee consider any other ways to handle that? Did you consider, for instance, not just letting that be decided in the future?
That is an option that could happen. And I think today, in today's hearing, is not necessarily about the transfer. It's about the changes in the operating committee and the proposed new operating, not committee, but proposal of who's going to operate the plant and those things, but not necessarily the transfer, and it could be decided in the future.
Okay, so that's viable. It's not a necessary component of this transaction.
Correct.
Okay. And by transfer, I want to make sure we're talking about the same thing. The transfer from Kentucky Power to Wheeling, we're not talking about the transfer to Liberty.
No, that's a
Okay.
whole separate case.
Okay, I just wanted to make sure that was clear, because I
Right.
thought we were both saying that, but I
Yeah.
didn't want the record not clear. Okay. So at least from your perspective, from Kentucky Power, the buyout provision, maybe we call it that, the buyout provision is not vital to these documents.
Correct.
Okay,
There is time that could be done in the future.
okay. Since I just did bring up Liberty, I know there has been some discussion and question about Liberty's involvement in these documents. To the best of your knowledge, what has been Liberty's involvement in these documents?
At our hearing that we had, I think it was on November the 30th, I think I testified that Liberty had reviewed, but since then I found that they have found out that they've been a little bit more deeply involved in helping in the overview and structure of those agreements. And I think Witness Haynes could elaborate more than I could be on that.
Okay. I think that's all I've got. Thank you,
Thank
sir.
you.
We'll take a short recess, and then we'll come back and finish with this witness. Great, let's see.
You're ready, sir.
All right, Mr. Overstreet?
Thank you, Mr. Chairman. As it turns out, in connection with Ms. Vensel's questions about the attachment to the data request, I think it was 1-16, Mr. Kearns does not have that information, and it might be more expeditious and if we could just provide that in a post-hearing data request.
And I can offer up that, because this is an issue on rehearing in 2021-4, and we have some information there, I think that's probably the better place to address it.
Okay. Okay, thank you.
Thank you.
Thank you, Mr. Chairman.
Okay.
Mr. Chairman, can I make a comment before you ask me questions?
Sure.
At break, Vice Chair Cubbage, I realized something. I think I was like two ships in the night. I thought we were on the same page about the transfer option. What I was thinking about is if we were to try to sell a plant between Kentucky Power and Wheeling is what I was thinking about, and those details definitely could be worked out later, the details of how that transpires. But when it comes to having a provision, and I think in 9.6 it talks about fair market value, and that selling of the plants is a backstop provision, that we do need some construct that needs to be decided on so that both Wheeling and Kentucky will know how to invest capital from today going forward through 2028. So I don't know if I was clear on that, because I had in my mind we were talking about just the sale and transfer of the plants.
Okay, and that was not clear, so I will ask a follow-up question to that. Couldn't capital investments even be just negotiated like they are now under the current operating agreement?
We just need to make sure that we've got a construct that is, workable under, so that both companies between now and 2028 and beyond will know what that construct is.
Okay, so it doesn't have to be what's in the new agreement. It could be the construct that's agreed upon between the parties anytime.
I would say that's a possibility, but what we put forward, we think this is a very workable and fair option.
Okay. That's all.
Sorry, Mr. Chairman.
It's fine. You were asked questions earlier by a number of folks, maybe including the vice chair, about how these changes came about. I think that it's your testimony. Let me find out here exactly where it is. Your testimony maybe in maybe even a data request response, where you were asked about how these changes came about. Do you remember responding about, let's see, yeah, this is a perfect response. So do you have, this is 421, right, Ms. Vinsel? This
Yes.
case is 421, right? Do you have your response to commission staff's first data request, item 14?
114?
1-14?
I've got KPSC 1-14 before.
That's right, and there are a number of subparts, and there's a question or a subpart L that says, explain whether Liberty Utilities has or has had any role in drafting and/or approving the proposed Mitchell Plant ownership agreement. Do you see that?
Yes, I do.
And then do you mind to go to your response? And do you see that your response starts between August and October 2021?
Trying to look because there's 3 or 4 pages or there's actually 5 pages of response.
Yeah, it's on the very last one, subpart L.
So it's on the last page?
The last page of those responses, that's right.
Okay, I'm on that last page.
You see the response L begins between August and October 2021?
Yes.
Okay. So I just give you a second to familiarize with yourself with that. I know there's a lot in this record, so just go ahead and take a second to read that.
Okay, I've read it.
Okay. So am I supposed to take this as effectively the operating agreement and the ownership agreement were negotiated between August and October 2021?
That's what it says there on L. But as I said earlier, that I think it was November the 30th hearing, I testified that, to my knowledge at that time, that Liberty had a review of the proposals. And since, they've had a much deeper involvement, as this explains, and Witness Haynes would be the one that could give you the detail of how much Liberty's involvement was.
Well, I guess I'm wanting to talk about the documents themselves. So the documents, the discussion about the need for, as it relates to the sale and Liberty and the Kentucky Power and everyone involved, the involvement and the negotiations seem to have been done between August and October of 2021. And then the new Mitchell agreements were filed with the commission on November 19, 2021, right?
Correct.
So do you know whether between August and October, whether or not, I'm not asking you to divulge confidential information, but do you know if the ownership of Mitchell was part of these conversations?
I'm not sure. I don't have any knowledge of that.
Okay, and is there any witness? Well, so I guess what direct knowledge did you have in providing this response? Because it says, I'll just read it, you've had a chance to familiarize yourself with it. Between August and October 2021, Liberty and its counsel were actively involved in discussions with American Electric Power Company and its counsel regarding the proposed new Mitchell agreements in the course of discussions regarding the sale of Kentucky Power to Liberty. And so I take your response to mean that the specific texts, or at least outlines or drafts or ideas of the new Mitchell agreements were part of those discussions occurring between August and October. And I just wanted to make sure that I understood your response to mean that.
Yes, and I'm not sure, Commission Chair, what date they were filed, but I know we submitted, I think it was sometime last week, we submitted witnesses to a lot of these requests that are here, and that's, I've got Steve Haynes is the guy that can give those details, because those discussions with Liberty, I was not involved in.
That's fine, and I'll ask Mr. Haynes some more detailed questions, but I'm going back to this based off your responses to Mr. West, because if you'll go back to if you have it available to you, your direct testimony that Mr. West was asking you about. I was a bit thrown off by one of your responses. A lot of information here. Let me just pull it back up. On page 8 of your testimony that Mr. West was asking you about, line 5 through 17 is a response and then a quote from a previous commission order. Would you agree?
Yes.
Okay. And so I understood your response earlier to be that the takeaway, the inherent, I think is the word you mentioned, what you read was the inherent takeaway from this language was that you also needed to come up with an ownership agreement or something around the ownership agreement. Is that accurate?
Well, I did use the word inherent from that ruling, if I'm not mistaken, I think this was October the 8th of 2021, that we needed to change the operating agreement and, put that forward, change the operator, ensure that Kentucky Power customers did not incur any ELG cost, and then how do we fairly unwind and get out of the Mitchell plant December 31, 2028. So that's why we put that forward.
Right, but I'm trying to understand, if the discussions with Liberty regarding the agreements was occurring between August and October, but your testimony earlier was that your impetus for the change in the agreements, especially the ownership part, were based off what you believe to be inherent in the October 8th commission order. How do you sort of describe that, what seems to be a mismatch in timing there?
Well, again, Commission Chair, I wasn't involved in those Liberty discussions, so I don't know what time frame, if they took place all in October or the end of September. I'm not sure when that occurred, and again, Witness Haynes could give more detail on that than I can.
Well, I appreciate Mr. Haynes can give a detail, but let me ask this. How did you know to provide your response to that data request subpart L earlier? How did you know for that to be your response? Did you have direct knowledge of those discussions between August and October, or had it been conveyed to you that between August and October, those discussions around the new Mitchell agreements occurred with Liberty and AEP Council?
I did not have direct knowledge. It had been conveyed to me.
Okay. And is the person that conveyed that to you Mr. Haynes or any other witnesses in this matter?
Mr. Haynes is the witness.
Okay. And so I just want to go back to your comment earlier. Would you agree that it was not the language inherent from the October 8th commission order that led the companies to discuss a change in the ownership agreement, that those discussions occurred prior to the commission's decision on October the 8th?
I have the same answer that I gave the AG representative.
Well, it's a different question, though. He said his question was about where you read the explicit requirement. What I'm asking is, are you aware of discussions or drafting around the creation or the need for an ownership agreement before the commission's October the 8th order?
And I may not have these dates right. I was aware that we needed to do something based on when the ruling was made that CCR only was going to be the path, case 2.
Well, something, yeah, I agree. Something had to be done, but there's a difference between changing the operating agreement and the creation of an ownership agreement. And I'm asking, do you have any direct knowledge of whether there were discussions about creating the ownership agreement prior to that October the 8th commission order that you were saying you were reading inherent in that a need for an ownership agreement?
It was after this order that I became aware of that.
Let me make sure that I'm clear. Before the commission's October 8th order, you were unaware of any discussions regarding an ownership agreement about the ownership of Mitchell post December 31st, 2028.
To my knowledge, once this order came out and CCR was ruled on and that we needed to get out of the plant by December 31 of 2028, at that point I knew we needed to make changes. This is what was the facilitator in my mind to make those changes.
Okay, and so did you direct Kentucky Power to negotiate and enter into the ownership agreement?
I had a review of it once I was made aware of it. But
Well, so this made aware of it. So this is an ownership agreement for an asset that Kentucky Power owns an undivided 50% interest in and has multiple hundreds of millions of dollars in rate base. Did you not direct somebody on behalf of Kentucky Power to draft that ownership agreement?
well, as it says in that response, and again, I'm not sure about those dates, but again, Witness Haynes is the one that can give you those details and the specific dates and who was involved and how that came to being.
Mr. Haynes doesn't work for Kentucky Power, correct?
He works for AEPSC.
Okay, well, you work for Kentucky Power, is that right?
That's correct.
Okay, so were you given the ownership agreement to review before you had ever directed anybody to do it on, to draft it or negotiate for that agreement on Kentucky Power's behalf?
We reviewed a framework and discussed it. But I don't recall those specific dates that occurred.
Was it done at your request or behest?
I helped direct it and review it, but at the same time, when you mentioned Liberty, or the Liberties mentioned in my response, Witness Haynes is the one that has been working with Liberty in detail, not me.
Yeah, and I'm beyond Liberty. I forget Liberty. They're not a utility subject to our jurisdiction. I'm asking, Kentucky Power has entered into, or intends to enter into, and has drafted for commission to review an ownership agreement regarding Mitchell. And I'm asking, forget review, I'm asking initiate, the impetus for, was that done at your direction? Or were you provided that by folks at AEPSC to then become involved in?
It was done at a joint operating committee with Wheeling and Kentucky Power that we needed to make changes, not only to the operating agreement, but the ownership agreement, since we have to be out of it, Kentucky Power does, by December 31, 2028.
Are minutes of the joint operating committee, or that's not called a joint operating committee, of the operating committee, are minutes kept of those operating committee meetings?
I'm not 100% sure, but I'm sure they are.
Okay. And I'd like to ask, as a posting data request, a copy of this operating committee minutes. Who on behalf of Kentucky Power worked to create the ownership agreement, to draft the ownership agreement?
I provided overview of the agreement. So
Right, but I mean, were there any other employees or counsel of Kentucky Power involved in the drafting or negotiation of the ownership agreement?
I'm not 100% sure, subject to check, but Brian West serves as my alternate, and he may have attended some meetings in my stead, but I'm not 100% sure. So he would be somebody else possibly from Kentucky Power other than me.
Is it your understanding that the rates, that your rates that you have today, that have been approved by this commission, recover a return of and return on the net book value of your Kentucky Power's 50% undivided interest in Mitchell?
Yes.
Okay. And are you aware of any of your assets any of your depreciable assets that you recover a return on or return of those assets' fair market value?
Not that I'm aware of today.
Okay, all right, I appreciate it, Mr. Madison. Ms. Blend, any redirect?
Thank you, Your Honor. Just a few questions. And the first line of questioning is hopefully going to clarify some of the discussion that the chairman just had with you, Mr. Madison. Mr. Madison, do you recall the discussion a couple moments ago regarding page 8 of your testimony and the commission's order in the investigation docket, case number 2021-00371,
Yes.
entered October 8th, 2021?
Yes.
During that testimony, you referred to having identified the need to enter into or change the Mitchell operating agreement after the commission issued its ruling on the CCR and ELG proposals that the company filed. Did I recall that correctly?
Yes.
Okay. Are you aware that the CCR and ELG case was a different case than the investigation case?
Yes.
Okay. And that was case number 2021-0004?
So, I mean, I don't have those case numbers memorized, but
That's
yes.
fair. Do you recall, Mr. Madison, whether the commission issued its order in the, what I'm going to call CCR and ELG case number 2021-0004, before or after issuing its October 8th, 2021 order in the investigation case?
I may be wrong here, but it seemed like it may have been in July, if I'm not mistaken, or it was previous.
Okay. And I'll represent to you, Mr. Madison, that it was in fact July 15th, 2021, as you recalled. So is it your testimony, Mr. Madison, did you become aware of the need to change the agreements or to enter into new agreements, create new agreements regarding the Mitchell plant's operations and ownership between when that July 15th order was entered and when the October 8th order was entered, or was it after the October 8th order?
No, it would be before.
Okay. Thank you. Earlier, one other line of questioning. Earlier, Ms. Vinsel asked you about the Mitchell Operating Committee's members. Do you recall those questions?
Yes.
And you testified that the members are the president of Kentucky Power or his or her delegate, the president of Wheeling Power and his or her delegate, and currently Mr. Kearns on behalf of the Service Corporation, correct?
Right.
Okay. Is that operating committee composition the same in the proposed ownership agreement that is included as Exhibit DBM3 to your direct testimony?
No, it's not going forward in the proposed, it's just the representative from Wheeling and representative from Kentucky Power.
Thank you. I have no further questions, Your Honor. Thank you.
I do have a couple questions, Ms. Blinn. I just want to make sure I understand. I can appreciate the known need to amend the operating agreement. I think that even the West Virginia Commission's orders in relation to their CPCN talked about the operating agreement. That's your understanding, right?
It's my understanding.
Okay, and do you still have your testimony up?
Yes.
Okay. It just may be helpful here, along the lines that Ms. Blinn was asking, on page 6.
I'm there.
Okay. So on page 6, you talk about you're asked, why is the company proposing to replace the current Mitchell agreement with 2 new agreements? You provide your response there. And then line 13, you're asked to further describe the Kentucky and West Virginia proceedings that led to the filing. Do you see that?
Yes.
And then, so that you talk about the history there. I take no issue with your description of the cases and what the commission's decisions are. Then lines 3 through 6, you talk about the West Virginia PSC authorizing the CCR and the ELG. They're on page 7. Line 6, you talk about how the West Virginia Commission followed up and said that they should pay the ELG cost to keep the plant open after 2028. Line 9 there, you talk about the West Virginia PSC conditioned that directive on Kentucky jurisdictional customers neither sharing in such costs nor sharing in the capacity and energy available from the Mitchell plant after 2028. Do you see that?
Yes.
And then the next part quotes the West Virginia Commission's order that specifically notes that changes in the operating agreement are going to be necessary. Do you see that?
Yes.
Okay. And then on to the next page, you talk about, that's page 8, are there any other commission orders that are relevant? And you say yes. The first is the one that I asked you questions about, Mr. West asked you questions about, the October 8th order in the commission's investigation that were related to, I think it was a request for a declaratory order. Is that right? And that was what you were talking to Mr. West about, the word inherent, that you read in that, inherent in that there needed to be done something around the ownership. And what I want to make sure I understand, because I feel like I'm confused now after your responses to Ms. Blinn, is this October 8th order, when you inherently read into it a need to change the ownership portions, and before October 8th order, you knew you needed to change the operating agreements? Or is it your testimony that before this October 8th order, before you read inherent, whatever your testimony was earlier about what was inherent in that order, had you already determined that it was necessary to change or to create an ownership agreement relating to Mitchell?
Well, as I was telling Ms. Blinn, I get confused on case numbers, dates, because there's been a lot of them with the investigative order and other things that we've done. But when the CCR Case 2 ruling was made, that we proposed that if Case 2 is ruled on, then CCR only and get out of the Mitchell plant by December the 31st, 2028. I knew then that we needed to make changes because we would not be with the Mitchell plant through 2040.
Right, so changes, but you're proposing to change the operating agreement, correct?
Yes, we are.
You're not proposing to change the ownership agreement because the ownership agreement doesn't exist currently, correct?
That's correct.
Okay, so when you say changes, you mean changes to the operating agreement and a whole new scheme to set up how Kentucky Power will sell Mitchell, correct?
Right. I mean, yes.
Yeah, to be frank, I'm trying to understand, is the ownership agreement something that Kentucky Power is doing on Kentucky Power's behalf for Kentucky Power's customers? Or does the ownership agreement have something more to do with the Liberty transfer?
No, it has to do with the Kentucky Power customers on the behalf of Kentucky, because we feel like that's a fair and equitable and reasonable way for Kentucky customers to be treated by proposing the transfer.
Okay. All right, thank you, Mr. Madison. Ms. Blend, any additional
Nothing
redirect?
further, Your Honor. Thank you.
All right, I appreciate Mr. Madison. I have one request. We won't be going past 4:30 today, but I just ask that you stick around in case there is any additional questions that somebody can't answer that you have the direct knowledge.
Sure.
All right, and Ms. Vinsel, I know it's a record, or it's a document that's already in the record, but given that I handed, well, I don't have it, but given that I handed Kentucky Power Council that exhibit.
I'm going to bring it back to him.
You can keep it, that's fine, that's fine. Given that we gave that to Mr. Madison, would you like to identify that as staff hearing exhibit number 2?
Yes,
Okay.
and I'll move that it be entered into the record.
And is there any objection to that being entered into the record as staff hearing exhibit 2?
No, Chairman, thank you.
All right, so we'll make that, and we'll make sure you get a copy of it, Candace, but that Excel document that's in case number 2021-00421, the Kentucky Power's Excel attachment to response PSC staff 1-16. All right, Ms. Glass, Ms. Blend, your next witness.
Kentucky Power calls Steve Haynes.
Okay. Mr. Haynes, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record.
My name is Stephen T. Haynes. I live at 3472 Stone Vista Lane, Columbus, Ohio, 43221.
All right. Which counsel is asking questions here?
John Crespo, Your
Mr.
Honor.
Crespo, you may proceed.
Thank you very much. Mr. Haynes, would you please state your business title and address for the record?
Yes, my title is Senior Vice President, Strategy and Transformation at AEP Service Corporation, 1 Riverside Plaza, Columbus, Ohio, 43215.
Thank you very much, Mr. Haynes. And did you cause testimony and rebuttal to be filed in this matter?
I have rebuttal testimony in this matter and data requests.
Yeah, thank you, Mr. Haynes. Regarding the data requests that you caused to be filed, did you have a recent correction to those data requests that you made?
Yes, for staff second set 2-03, an Excel spreadsheet that was responsive, we found an error in it, and it's regarding the CapEx adjustment in the fair market value calculation. And so we, rather than, and the blue cell in the spreadsheet highlights the change, rather than subtracting from $100, which was the sample CapEx investment example, we realized it should have been 50% of the $100 as Kentucky shares 50%, and then subtract. And then that lowers both the WACC as well as the overall CapEx adjustment in the formula.
Thank you, Mr. Haynes. We would like to have that corrected exhibit marked as an exhibit in this matter. May we approach?
Sure. This is the same document. Do you mind to provide? Forward with one. This is the same document that was filed this morning.
That's correct. We thought for convenience it'd be better to provide copies since it was such a recent change.
I'll mark this as Kentucky Power Hearing Exhibit 1.
Thank you very much, Your Honor. And Mr. Haynes, if I ask you the same questions today that are in your rebuttal testimony and in your data responses, subject to the correction that you just made, would your answers be the same?
Yes, they would.
Thank you, Mr. Haynes. Mr. Haynes is presented for cross-examination.
Ms. Wenzel?
Yes, thank you. Good morning, Mr. Haynes.
Good morning.
Please let me know if you have any problems hearing me.
Okay.
Got a couple questions that got passed on to you. Can you tell me, under the ownership agreement, does the valuation process for the buyout price give any credit to Kentucky Power for its share of the CCR compliance project that was approved in case number 2021-4?
The methodology is really a methodology that looks at the overall operation and the value of the plant and then, does 50% of that valuation. So that valuation that appraisers are going to use, and I'm not a subject matter expert having done appraisals, but my understanding is that they're going to look at the overall cost of the plant, assets of the plant, and the revenues that the plant would bring in to determine the fair market value. And of course, again, the methodology in this case has 3 appraisers in that approach. And so the CCR being assets that are part of the plant in both the costs as well as running the plant to sell power for revenues is going to be then considered in that overall methodology.
Mr. Haynes, do you know what, at the time of the sale, what actions will Wheeling Power take to fund its share of decommissioning costs?
So I presume you're talking about in the buyout provision if we do the fair market value sale?
Yes, under the ownership agreement, the decommissioning costs are to be, just to be clear, are to be developed by engineering or consultant experts with experience in decommissioning costs. And we've got the methodology for Kentucky Power share. What about Wheeling Power share of the costs that are determined at that time? Will there be any steps taken by Wheeling to fund its portion of those costs?
We don't really know when Wheeling's going to decommission the plant is my initial statement, and so the funding of that I would expect to, similar to other AEP plants that we've retired, to be funded concurrently with decommissioning. And a number of our sites, we've been successful actually at selling the site to a third party and then funding that project over time as they do the work. And so the funding could be all at once, but more likely to be funded over time as you do the project. But again, Wheeling has the option to run the plant to 2040, and that is their current planned retirement date, so that would be the expected timing of the decommissioning funding, again, from their I presume, operating funds or debt issuances, however they choose to fund it. But again, we don't really know that exact timing or that exact method at this time.
Mr. Haynes, do you have a copy of the proposed ownership agreement in front of you?
I can turn to that, yes.
Okay, I'll bring it up. In Article 14, there's a definition for the CapEx adjustment.
Yes, I see that.
You see that? Okay. And for the record, this is on, it's Article 14 of the proposed ownership agreement. It's on page 27 of 34 in Exhibit DBM-3. Do you want to take a moment to read that definition?
Yes, I'm good, thank you.
Would you agree that under this CapEx adjustment, that it's going to include ELG costs?
So, again, remembering that this is the fair market value minus the CapEx adjustment being the value for Kentucky's 50% share, since Wheeling will have made that ELG investment, then yes, it will include both the ELG investment as part of the CapEx adjustment for 50%, as well as the WACC on that investment because of the fact that Wheeling Power and its customers funded the capital investment in the ELG for that period of time. So yes, it will be included.
And any amount in excess of the 50% attributed to Wheeling Power is then attributed to Kentucky Power, correct?
Since the ELG is all excess in the sense that Wheeling did it all, then I think your statement is correct.
Staff has nothing further.
Thank you.
Mr. West?
No questions.
Mr. Kurtz?
Thank you, Your Honor. Good morning, Mr. Haynes.
Good morning.
All right, so fair market value is a defined term under Article 14 of the proposed ownership agreement.
Yes.
Essentially, it's an arm's length transaction between a willing buyer and a willing seller to determine the price.
It's intended to provide an equivalent to an actual arm's length transaction, but of course is not an actual transaction.
So the process for the buyout price is that first Kentucky Power and Wheeling are to try to negotiate a fair market value price beginning no later than June 30, 2026, correct?
Correct.
Okay. And if the two utilities can agree on a fair market value price, that has to be approved by both commissions, West Virginia and Kentucky, for it to be binding, correct?
Correct.
Okay. And if both utilities cannot agree, or both commissions don't approve, then it goes to the mandatory 3 appraisal process, correct?
There is one other option. Retirement can be in the current draft. Wheeling can choose to retire, and then it would go to this option.
Okay. So if Wheeling does not elect to retire early, the early retirement, it'll go the process that I indicated. The two utilities have to get an agreement on fair market value. The two commissions have to approve fair market value. That's the transfer price. And if that doesn't happen, then it goes to the mandatory appraisal process. Correct?
You're calling fair market value, yes. So either a negotiated fair market value, or if not retired, then yes, it goes to this selection of appraisers to do the fair market value, correct.
And if it goes to the appraisal process, that decision of the 3 appraisers, or the blended costs that they come up with, is binding on both commissions and on both utilities.
It's binding on the two owners to make a transaction, but they will still need to go get approval from the two commissions. And I presume FERC as well, but this commission will need to approve whatever that price is.
When it says it shall be binding and conclusive on the owners, being the approval process, what role would this commission have at that point?
I think that the intent of that language is saying, and I'm not a lawyer, but I think the intent is to say that they can't just say, well, I didn't like the price, I'm not going to take that to my commission for approval. But the intent is that they need to take that price and proceed.
And under the draft of the ownership agreement, this would be, this process, this reappraisal process with the binding and conclusive pricing on the owners would be part of a FERC rate schedule, correct?
I'm sorry, did you say pre-appraisal? I'm sorry.
Three.
Oh, three appraisals, sorry.
Three appraisers, the binding and conclusive process that'll be binding on the owners would be part of a FERC rate schedule.
I'm not an expert on that, but I'm presuming that it would be part of a FERC filing as well.
So under the doctrine of federal preemption, what role would this commission have to say, we don't like the three appraisal determination, we think something else should be the price? Or would they have any role?
I'm really not an expert to know how the interaction of the states and federal works, but I do want to make it clear that the company's fully supportive of this methodology, and but we have received negative feedback from a number of parties, and so we have offered an alternative in my testimony, this unit interest swap structure, which gives slightly different options to both the companies as well as the states in looking at what the disposition of the plant would be in 2028.
Now, let's assume we're in the 2026 timeframe, no later than June 30, 2026, when Kentucky Power and Wheeling are negotiating a fair market value before it goes to the mandatory appraisal. If I'm Kentucky Power and I say to Wheeling, hey Wheeling, the $32.5 million of payroll that Mitchell provides to West Virginia, 225 full-time jobs at $144,000 on average total compensation. We think that should be considered Wheeling because that's a value to West Virginia that should be included in the price. Would that be
I'm going to object, Your Honor. Mr. Kurtz has not laid a foundation yet for any of the numbers in his question.
Okay, that's in Mr. Collins' testimony, page 12, and that came from the CCR ELG case data responses, the number of jobs and the taxes and the coal for the Mitchell plant.
Mr. Cresswell, would you like to continue your objection?
I do continue my objection, Your Honor. Mr. Kurtz has not laid a proper foundation for those amounts. If you'd like to do so through Mr. Collins, I think he can do that, but I would like to maintain my objection. Thank you.
Mr. Collins already presented his testimony in this matter. Is that right, Mr. Cresswell?
He has presented his testimony, but he's not yet testified, Your Honor.
Okay. So you'll be able to, I'm going to overrule it because you'll have an opportunity to cross-examine and test the veracity of Mr. Collins' testimony. Continue, Mr. Kurtz.
Let me go back and say, I'm representing Kentucky Power, and I say to West Virginia, you need to take into account the value of all the jobs and the payroll in determining the price. Would that be a relevant factor in the fair market value?
I would say that it is certainly a qualitative factor, but I'm not aware of any transaction where there's been an actual quantitative adjustment known that has impacted the price based on economic benefits to one party versus another.
Because if West Virginia said, we're not going to consider that, and if you don't like it, we'll take it to the three appraisers who won't, the three appraisers won't consider the jobs in West Virginia, will they?
No, it's not likely that they'll factor that in. They'll look again at the economics that I described earlier.
Right. And if I say to West Virginia, what about the $10 million of annual state and local taxes that Mitchell provides? And West Virginia says, we're not going to consider that because the three appraisers will not consider that, the taxes. West Virginia would be correct, wouldn't it?
I would not, I think West Virginia would be correct assuming that it would not be considered, the taxes would not be considered.
And if I said, well, what about the 1.2 million tons of coal, this is 2020, and it depends on capacity factor and so forth, but what about, all the coal comes from West Virginia to supply Mitchell, correct?
It does today, but that doesn't mean it will in 2028. So the market does change on a frequent basis.
Isn't there a dedicated mine to serve Mitchell with a dedicated conveyor belt that just sort of moves it right in?
For the high sulfur coal, there is a dedicated belt in mine today. The low sulfur comes from elsewhere.
Okay. And if I were to say to West Virginia, what about the coal? And West Virginia said, well, the 3 appraisers won't take that into account, so we're not going to take it into account. West Virginia would be correct, wouldn't they?
Again, it is a factor in the cost of running the plant, but the source would not be taken into account.
Okay. The Mitchell ownership agreement is a condition, the closing of the Liberty transaction, is that correct?
Yes.
Okay. And you're very familiar with you were instrumental in the Liberty negotiations, so you're aware of that deal?
Yes, I was involved in the Liberty negotiations.
Okay. And AEP will be receiving a premium of approximately $625 million on its equity investment from Liberty in that transaction?
I don't know the exact number. I would have to check it.
Okay, Kentucky Power has $1 billion of equity expected at the time of mid-year 2022 when this deal is expected to close, correct?
Yes, once all the approvals are received, yes.
Okay, and Liberty's paying $1.625 billion for that equity, so that would indicate a $625 million premium.
At that equity level, yes, it would.
Okay. Now, the way this is structured is, I'm going back to Mitchell now, the fair market value. Let me just back up. If Mitchell resolution is a condition of Liberty closing, if Liberty closes, AEP gets this equity premium we've discussed, correct?
If the transaction closes, we receive a premium, yes.
So right now, the way the deal's structured is it's kind of a zero-sum game between West Virginia and Kentucky. One gets more, one gets less.
I don't understand the question. I don't understand who gets more and who gets less.
Well, in the transfer pricing, if Kentucky pays more, then West Virginia receives more. And if Kentucky pays less, West Virginia receives less.
And the transfer price under the fair market value construct, Wheeling would be paying Kentucky.
If Wheeling pays Kentucky more, then West Virginia pays more. It's still a zero-sum game, one way or the other. It's just between the two jurisdictions, whatever dollar amount is
If you're saying, I don't know if you're saying it's zero sum because AEP owns both parties now?
No, it's because there are these, my point is this: if the deal closes, if Mitchell closes and Liberty closes, AEP gets $625 million. But right now, the Mitchell transaction is simply between West Virginia and Kentucky. Here's my question. Has AEP considered making a shareholder contribution to get the deal done between West Virginia and Kentucky?
I object, Your Honor. That information is not relevant to that case. This case, there's a transaction case that's pending before the commission and another matter where Mr. Kurt's going to ask his question about, what may or may not happen in that other case and what the company may or may not do.
Well, I think it's relevant to this transaction and to the buyout pricing, and I believe that's my last question. And the question is simply, has AEP considered a shareholder contribution to get the deal done between West Virginia and Kentucky with respect to Mitchell?
I'm going to sustain the objection.
Okay.
Do you have any additional questions or would like to ask it differently? I don't know how you're going to ask that differently that I'm going to sustain another objection.
Nope, that was my last question. Thank you, Chairman.
Mr. West, you didn't have any questions for this witness? Vice Chair.
I do have a few questions. Good morning still.
Good morning.
I want to go back to your Exhibit 1. I just want to make sure I understand what this is relevant to in the the proposed ownership agreement. This is an illustration of the apportionment of costs under Article 6, is that right? Or is this or is the bottom part meant to be an allocation of the CapEx adjustment under 9.6?
It's under 9.6, correct.
And then that takes me to, if you can, because I've focused now more on what Mr. Madison testified to when we came back from the break. And he said, he had said previously that the 9.6 buyout essentially could be left out as far as Kentucky Power is concerned, but we needed a cost allocation. Was he talking about the Article 6 allocation, or was he going back and saying, you do need part of the 9.6 buyout transaction, if you know?
Yeah, so we need both. So we, because of the fact that Wheeling Power is making all of the ELG investment, so both the capital as well as the O&M, we do not have under the current operating agreement the ability for costs to be split unevenly. So you have the fixed costs and I'll call it volumetric costs related to dispatch are all split evenly. And so we need the ability to have a different cost allocation of these costs. And so we need, again, we've chosen to do it in a new agreement, in this ownership agreement, to allocate those costs. Also, what you have is clearly different incentives at Wheeling and Kentucky for how you invest capital when one, I see it as potentially being out in 2028 and saying I don't necessarily need to be spending in capital projects that go to 2040, and then you have Wheeling who's saying I want to be able to run the plant beyond 2040 and would be spending on replacing assets and pumps and things that would go beyond 2028 to 2040. And so we put in here in I believe it's in Article 7, the ability for CapEx to be split differently between the two companies as you go through these projects. And that is also then, as I show in my updated exhibit, part of the CapEx adjustment for not just ELG, but also these differing CapEx that is made between now and 2028 would be done, split differently because of the different interests of the two parties.
So I guess I still don't understand, if you've got Article 6 and Article 7, why then would the CapEx adjustment under 9.6, it's an adjustment to a default buyout price, why would that be vital?
So what we need 9.6 to have some methodology for disposing of the plant in 2028. It could be this negotiated price, or it could be, again, as a backstop, as the fallback option to make sure we have certainty, a fair market value approach. It could also be the ability to swap the undivided interest, which is part of what complicates this, so that each party owns one unit and then shares in the common plant. And then each party could choose to do a number of things with their individual units. So we really need 9.6 to give us that certainty of what's going to happen before 2028 so that we know what happens. So this CapEx adjustment's only required if you're doing the fair market value approach. And then it would be required, we think, to make it fair on CapEx as part of the fair market value. It's a deduction because of the fact that Wheeling has made investments that Kentucky did not make.
Okay, so just to, I think, unravel that so I understand it. Having done some transactional work in my prior lives, I understand why you'd like the certainty of the buyout provision. I get that. But what it seems to me that you're saying that it's desirable to have that as far as the cost allocation, but 6 and 7 would be how you're going to be allocating until 2028 anyway. That CapEx adjustment doesn't kick in unless negotiations fail. Is that right?
The CapEx adjustment wouldn't kick in unless negotiations fail. That's correct.
Okay. I want to also revisit a line of questioning, and I think it was Mr. Kurtz, where he was asking you about whether or not if we go to the default provision with the appraisers, that if that cost would have to come back to the commissions. And I understand you're not a lawyer, but I know it's written that if there is a negotiated price, those would be taken to the commissions for approval. Was it your intent in your role in negotiating this that the default price would also then have to come to the commissions for approval?
Again, because, a couple of things. One is because it's a pretty important transaction, but B, we don't have the actual agreement yet. So that Mitchell Interest Purchase Agreement, which is not been set forth yet as even a draft, since we don't have that agreement drafted today because we don't have a transaction, again, it just seems to us that you would come back to the commissions for approval with those details.
Okay. So this is obviously an assumption. Let's say Liberty does purchase Kentucky Power. We're in 2028. You're still acting on behalf of AEP. You would have no objection to the buyout price coming back to the commission if you've gone to the default?
Yes, that's correct.
And even making that explicit in the agreement?
Yeah, that's correct.
Okay. I don't have any further questions.
Mr. Haynes, how long have you been with AEP?
I've been with AEP about 37 years.
Have you been exclusively employed at AEPSC, AEP Generating Company? I'm just curious, which AEP companies have you been employed by in your 37 years?
I've always been at AEP Service Corporation.
Okay. So AEP Service Corporation provides assistance and services to each of the Kentucky Power operating companies, is that right?
Kentucky and all the AEP operating companies, yes.
So, the operating companies, well, let me ask this, have the number and distribution of operating companies at AEP changed since you were first employed?
Well, AEP has changed. We had a merger with Central and Southwest in the year 2000 that substantially grew AEP. And then since then, in terms of actual operating companies, it's been the same.
Okay. Are you aware of AEP having divested any regulated operations prior to the proposed sale of Kentucky Power?
All the divestiture that's happened has been because of deregulation in Texas or deregulation in Ohio, where generation assets were divested, but not any distribution or transmission operations.
Okay. And you all have had divestiture of non-regulated affiliates, right? Coal barge companies, things like that?
Yes.
Okay. Let's take Ohio, for instance. Ohio deregulated in excess of a decade ago, correct?
Yes.
And Ohio Power Company is Kentucky Power's affiliate and an affiliate of AEPSC, is that right?
Yes.
Ohio Power Company used to own Mitchell, is that right?
Yes.
Okay, and Ohio Power Company actually sold their interests to Mitchell, to Wheeling, and to Kentucky Power, is that correct?
Wheeling and AEP Generation Resources for a period of time, and then AEP Generation Resources to Kentucky Power.
Okay.
See, I'm sorry, do I have the time? I may have it.
I think it may be the other way around.
The other way around, sorry, if it's AEP Generation Resources to Wheeling, sorry.
Were you involved at all in the divestiture? You know, as I understand it, there was a proceeding at the Ohio Commission where Ohio Power Company had kind of kept their generation for a while, participated in PJM as an FRR entity, and then sometime, we'll say in excess of a decade ago, the Ohio Commission ordered Ohio Power Company to divest from its generation by a date certain. I'm thinking maybe it's 2015. Does that sound about right to you? Is that your understanding?
Yeah, I mean, I was not directly involved, but that's about right.
Okay, and so Kentucky Power bought their half interest from Ohio Power Company. And do you know at what cost Kentucky Power bought their undivided 50% interest in Mitchell?
My understanding is it's net book value is the price.
Okay. And do you remember, have you ever reviewed that record or have any understanding of that process or proceeding at all?
Not really, no.
Okay. Had you looked at the 3 appraisals to determine fair market value in that proceeding?
Not to my knowledge.
Would you be surprised if there weren't 3 appraisals to determine fair market value, the higher or lower fair market value versus net book value in that proceeding?
Would I be surprised if there weren't any? No, I would be surprised if there were, actually. So-
Okay, so why, I guess what I'm trying to understand is the determination of fair market value with the appraisals seems to be something new. And I'm curious where you all pulled this out of thin air to do the 3 appraisals and to get rid of the high ones.
Yeah, so again, this is a consultation including with outside counsel who worked on other transactions and said, here's a way to do this. In other words, because one of the questions was, how do you make something arm's length? How do you make it so it works if it's affiliates? How do you make it work if it's an unaffiliate? Because we don't know what happens between now and 2028. And again, that's not even counting the Liberty. Liberty obviously could put us in that situation. And there were not a lot of suggestions other than fair market value, because again, it is intended to without actually doing a transaction with a third party to give an equivalent value of what a third party would pay for a property.
So, I guess, taking a big step back, you were involved in this process of determining this, I'll call it a fallback position.
Right.
Did anyone that you're aware of review the proceeding or the process leading to Kentucky Power's purchase of the undivided 50% interest in Mitchell to determine how they calculated or proposed what the fair market value was?
Well, we had consultation with our internal regulatory personnel and counsel, so that they did make us aware of how that had happened before. So we were aware of it.
You were aware of it. Why was it ignored or not taken into account? Or why was a different determination chosen?
Well, the key for us was that because we're allowing first step to be a negotiation, and then book value could be that negotiated price, we were only trying to come up with the backstop. We're trying to come up with something that says if you can't agree on book value or any other price, we need to have something in fair market value as that backstop. So we weren't precluding book value as a price.
So regardless of what the agreement says, you would agree that the commission has statutes that explicitly discuss affiliate transactions, that you note those in your testimony, right?
Yes, yeah, absolutely.
Okay. And so this idea of we're not doing this or we're not doing that, you would agree that you all aren't necessarily in the captain's seat on the determination of what these purchase prices or sale prices are as much as the Kentucky PSC and West Virginia PSC are.
We absolutely need to come up with a transaction that will be acceptable to obtain approval, or we won't have any transaction.
And that's what I guess I'm confused by, is if there's already been a transaction proposed to this commission for this exact same interest in the exact same asset, why was it proposed to deviate the determination of market price as in addition to net book value?
Again, as described in my testimony, and again, I wasn't involved intimately in the Ohio Power, but it was a different situation where we were forced to divest, and an affiliate clearly who had options, and this was one of the options, and Kentucky Power needed capacity. This situation, we have wheeling and orders, as was discussed with Mr. Madison, that say invest in ELG, run the plant to 2040, and here we have orders that say don't invest in ELG, which as of now would mean not operate after 2028. That means there's not a clear path of alignment on book value as a price, and it has a very different potential value to each party because of their long-term path that the decisions of the two commissions have laid out. So you need an alternative when there's not a clear path, an alternative to book value.
Okay. So, but you cited the statute that specifically states for affiliate transactions in Kentucky, it's the lesser of market and net book value, correct?
For affiliate transactions, yes.
Okay. And Kentucky Power and Wheeling Power are affiliates, correct?
Yes.
Do you know if Wheeling recovers terminal net salvage value in their depreciation rates for Mitchell?
I'm not aware with that. I think witness Mr. Cash would be better to address that.
I was hoping Mr. Cash would go before you, Mr. Haynes, to be frank, for these line of questions. So, walk me through, so you're aware that Kentucky Power used to recover terminal net salvage in the depreciation rates for Mitchell, correct?
I'm not familiar with anything around depreciation, salvage, or any of those topics.
Well, I thought you addressed, in your rebuttal testimony, you and Mr. Cash together, in your determination of these calculations, discussed in rebuttal Mr. Collins' testimony regarding terminal net salvage value. Is that not correct?
I'm sorry, yes, correct. So related to fair market value, we believe the appraisers who really use the best practice of appraisal methodologies and are experts in doing appraisals for this type of asset would include all the appropriate calculations, including that in their appraisal. So that's where kind of it relates to my testimony.
Yeah, so how is somebody that's appraising something, how is their appraisal of what its market value is take into account what amount of depreciation for decommissioning, or what amount of cost for decommissioning an entity has already recovered in depreciation expenses for that asset? How are they doing their appraisal going to take that into account?
So really, that's independent of what's being charged to customers and what's being depreciated. They're really going to be looking at the assets and the cash flows and the costs that I described before. So the specific balances and depreciation rates, and I'll say estimated salvage is not good. I mean, I'm sorry, the estimated salvage would be there, but what's going on in the rates and in the approved depreciation is not really. It's not the focus of the appraiser's work.
So when does it come into account?
It's going to come into account once you have that transaction that we talked about. So I've got the fair market value. We agree that we'll make that the price from Wheeling to Kentucky. And Kentucky comes here, then you would be assessing what have we depreciated versus that price that's being paid for your assets. It would be part of that sale transaction.
So it comes after the determination of the fair market value, and then it's either credited or debited from that amount.
Again, I don't know debits and credits, but yes, it would be properly charged to customers based on the net of that.
And in the event, well,
She's going to change it.
so I'd like to ask you about the timing for a minute. You heard my questions to Mr. Madison earlier, correct?
Yes.
Do you know whose idea it was to create the ownership agreement?
I can't recall the exact, a single person. Again, I believe there were discussions. And so with the two differing orders, so the July 15th and August 4th orders, we had a concern with how we were going to manage that. And then we wanted, again, to have an agreement that would not just satisfy affiliate concerns, but also would satisfy an unaffiliated owner of one of the 50% shares, which of course we had that possibility with a sale process of Kentucky Power. So, and again, I don't recall the exact timing, but post-August 4th West Virginia order, we did proceed to to first, as Mr. Madison said, come up with a framework, and then we proceeded to have drafting done of the two agreements that are Mr. Madison's exhibits to replace the current operating agreement. And then later in the process, so again, I can't remember again the exact dates, but as it was stated in that data request that I'm now partly sponsoring, sometime in that August to October, we first initially floated the concept with Liberty, and then later said, okay, once the operating committee had signed off, here are drafts of these two agreements, are they acceptable for making? And again, as part of the discussion, it was determined in that negotiation that they would become part of conditions for the transaction, because again, AEP needed them to be approved in some form, whether there was a sale or not. So Liberty agreed to, and AEP agreed to make those approvals condition precedent to the transaction.
Well, so you said AEP determined they were needed, and you're talking about both of the Mitchell agreements.
Yes.
And my question is, what's the basis for that determination that they are, quote, needed?
Oh, okay. Yes. Sorry. So yeah, again, so the two orders, the West Virginia order and the Kentucky order, basically stated, again, different paths for the plant with no certainty for how, again, with an undivided interest. If it wasn't undivided interest, this would be a simpler situation, because if one owned one unit, one owned the other unit. But with undivided interest, there was no clear path for how Wheeling, putting all the investment into ELG, was going to be able to operate the plant without encumbering Kentucky with costs potentially, unless Kentucky, again, had a disposition either to a third party or to Wheeling for its share of the plant, because of the order here saying not to invest in ELG. And the current operating agreement says if one owner makes an investment, this is in 7.9 of the current operating agreement, then it has essentially the ownership of those assets. And so post 2028, when it's required to have ELG assets to operate Mitchell, if both parties choose to continue to operate, only Wheeling would have access to those ELG assets. So again, those facts pointed us to we needed cost allocation. We had a situation where Wheeling wanted to run the plant potentially long-term, and it needed to be there for the operator, doing more around the CapEx decisions and running the plant. And then we needed to determine how to do the disposition of the plant between the two owners by 2028. Again, all driven from those two orders.
So I completely agree, for whatever it's worth, that changes to the operating agreement need to be made. I have the benefit of having been a commissioner that put that in an order that said that promptly amend the operating agreement. I'm asking about the ownership agreement. You keep saying it's needed, and you're talking about things that are happening in 2028. And so I just want to get down to the impetus or the timing of the ownership agreement. Is it your testimony that is unrelated, entirely unrelated, or at least initially unrelated, to the sale to Liberty?
There's clearly, Liberty has interest in having this resolved, but AEP needs to resolve it no matter what, regardless of the sale to Liberty. If the sale to Liberty was not approved, we still need this resolved. So we need to know how CapEx is going to be invested at Mitchell. Again, as is noted with that CapEx adjustment that was being asked about a few minutes ago, that you have very different interests if you are running a plant to a 2028 retirement date versus running a plant to a 2040 retirement date. You have the ability to, I'll say, make fewer investments, fewer outages, whatever, if you're running to a closer date. But you need to keep the investments going to run to 2040. So you really have different decisions, both primarily CapEx decisions, but it could be even potentially operating decisions about outages, depending on what your interests are. So we do believe that long-term point of 2028 impacts today.
That can be addressed with the operating agreement, can it not?
You could put all these provisions in the operating agreement, but we would think there would be a number of provisions, a lot of provisions that would be needed in the operating agreement.
Or, but the operating agreement already had provisions pre these amendments that discussed if there are differing opinions as to investments between one party and the other, correct?
They had just one sentence on that, and it, again, was not very clear, and it would not have handled these differences in CapEx investments. The CapEx investments is part of the proposed ownership agreement.
It's March 1st, 2022.
Yes.
Beginning January 1st, 2029, the assets that are necessary to operate, is it your understanding that the assets that are necessary to operate beginning January 1, 2029 are going to be owned exclusively by, or at least the portions related to compliance with ELG, are going to be exclusively owned by Wheeling Power?
They would be owned by Wheeling Power unless there's some transaction between Kentucky and Wheeling to, I'll say, gain access at whatever price, cost, to those assets. Otherwise, they would exclusively be to Wheeling Power's benefit.
Other than sale of Kentucky Power's undivided 50% interest, is there anything in any of these agreements that speak to that cost that you're talking about, that Kentucky Power would have an option to receive energy or capacity from Mitchell beginning January 1, 2029?
I'm sorry, other than what kind of sale? Just make
Other
sure.
than the ownership agreement that provides a backstop to the disposition, complete disposition of ownership by Kentucky Power of their undivided 50% interest in Kentucky, in Mitchell. Is there anything else that you all proposed in either of the Mitchell agreements that discuss that situation?
Well, again, the
you were
only
just
thing that
mentioning?
we've proposed is in my rebuttal testimony to do the swap, which gives some additional optionality to Kentucky Power and the ability to, you could, again, work out an ELG transaction with Wheeling and continue to operate a single unit, or you could retire the unit, or you could even sell it to a third party, but that third party would need to work out a transaction with Wheeling to use the ELG assets as well.
Yeah, so I have a couple questions about that. I guess the first is Wheeling CPCN, your understanding, to do ELG for both units or for the entire station at Mitchell?
Again, I'm not an expert in it, but my understanding is the ELG would be for all the ash facilities, so it would be for both units.
So going back to my first question, I don't think I'm clear on it. Was it somebody in particular's idea to create the ownership agreement?
Again, I believe it would be a combination of the operating committee, certain, council, regulatory council, and myself and those of us who are, my strategy area covers a broad swath of things, including these kind of opportunities. And so we literally discussed, say, what do these orders in these two states mean? How would we handle this? And then also, obviously, how would we handle this in light of a potential sale of Kentucky Power? And so all of that came together, which again, we brainstormed a limited number of ideas, because only a limited number of ideas would work, and this was our conclusion as the proposal. But with the feedback we received, and frankly, in both states, negative to the fair market value approach, we wanted to give an alternative in this unit swap approach.
So let me ask you about the unit swap approach.
Okay.
Is it your plan to give Kentucky Power Mitchell Unit 1?
No, there's no predetermined, there's no predetermination of who gets what unit.
So, and this is not a characterization of the units, but what would keep, in a situation like that, one state from getting an asset that's worse performing than the other asset?
Well, unless they're exactly performing the same, probably someone is going to get a worse performing asset. I think the question is how much worse, and is it close? And then one of the key things is there can be a payment between the two parties for this, right? If they can come to agree that, you're getting the better unit, I should get some, a payment for that, that certainly can be agreed as part of the transaction.
And then on your updated responses, Kentucky Power hearing exhibit number 1.
Yes.
This is so explain to me what this amends, what this CapEx adjustment would apply to.
Right, this would only apply to the CapEx that is being made by Wheeling Power in excess of the 50/50. So if there's assets that are going in place, and this is all in section 7, going in place and retiring before 2028, it's 50/50 between the two owners. If they're going in place, but they're going to run to 2040 or somewhere beyond 2028, there's an allocation that says what's the life of that beyond 2028, and 50/50 for the time between 2028, and the higher allocation is to Wheeling, as well as the ELG assets is 100% to Wheeling. So if there is a fair market value buyout, the fair market value then subtracts an adjustment for all those different assets that Wheeling invested above a 50% allocation between now and 2028.
So, but this would be applicable to a net book value transaction, is that right?
That would be applicable to a fair market value transaction.
So if I guess what I'm confused by is why can't something like this, and I don't mean this, but something like this, adjustments be made to a net book value calculation to remove those concerns around making investments, up to and beyond 2028?
If the two parties agreed in one of our options, which is a negotiated transaction at a book value price, they could still include a CapEx. I think the CapEx adjustment absolutely could be included with either a book value price or a fair market value price.
And I'm not suggesting that. I'm wondering why this was only brought up in context to a backstop that included a whole new process for valuation instead of just applying your concern. I've heard your concern today about different investments, and that was the exact impetus for these changes. Why then did you go out and do a completely different methodology for valuation instead of just addressing your concerns around the investments in the context of net book value?
Again, there were concerns that net book value would not be agreed upon, and if there was no price agreed upon, we would not have a disposition of the plant in 2028. We wanted, again, to have a backstop that worked. The CapEx adjustment absolutely could be applied in a net book value process, and that's something we could consider doing in the agreement.
And I just want to make sure I understand your testimony.
If the parties agree to that.
I just want to make sure I understand your testimony. When you say can't come to an agreement on net book value, you're not, net book value is an objective amount, right? It's
Yes.
It's just the depreciated original cost, correct?
But I'm just saying, if there, again, in our construct, if there is an ability for a negotiated transaction, and if they can't agree on net book value there, no agreement at all, we would then, and under the current agreement, go to a fair market value.
And I'm trying to clarify my understanding of what you keep saying, agreement with net book value. Net book value is original cost less depreciation. Is that your understanding?
Yes.
Okay. When you say agree on net book value, you're not saying agree on what net book value is. You're saying agree that the sale amount should be net book value. Correct?
Yes, if they agreed on sale amount being net book value, which could also include all the other adjustments like coal pile and decommissioning and all those things. But yes, that's what I meant, was a price of net book value.
And that's what I want to understand from your testimony. It seems like in terms of net book value, it's original cost less depreciation, take it or leave it. If they can't agree with that, then we go to this alternative. I want to make sure I understand that doesn't preclude the ability of an adjusted net book value calculation taking into account different levels of investment, asset, coal inventory. It doesn't preclude any of that, correct?
No, it's reasonable to include that in that kind of transaction.
Okay. All right, I appreciate it, Mr. Haynes. Mr. Crespo?
Thank you very much, Your Honor. Mr. Haynes, I'd like to follow up on the last line of questioning. Regarding the potential unit split that you were asked about, there would be a number of different ways in the future to value that unit split, if there was a difference in value between the two units, would there not be?
Correct.
And that unit split, it will be determined whether or not that happens in 2025. Is that right?
Under the current drafting, it needs to be done in time for the PJM capacity year. That's 3 years ahead, so 2025.
Right. And one of the benefits, you would say, from the unit split is knowing what's going to occur 3 years in advance of when units need to be split in 2028.
You would need to, you're talking in terms of valuation, make sure I understand the question. Yes.
Yes,
You would
Mr.
need to
Haynes.
understand how to estimate the value of the units. That is pretty common when it comes to, PJM. You need to understand if you're going to have enough value in a unit to keep running it, so that's not unusual.
And knowing the answer to that question of what would be the disposition of the units that far in advance, would that aid the owners in making decisions, in your opinion, about how to make future CapEx investments in each of the units?
Yes, that is something I didn't mention, is obviously, if you're going to make a decision related to whether you want the unit in a swap, you're going to need to decide how to invest in that unit post-2025.
And as you will recall, there's been testimony and questions in this case about the condition of the units today and which of the two units might be better than the other unit. Do you recall some of that testimony earlier?
Yes, with Mr. Kearns.
And as you understand it, from having observed that testimony, it's not predetermined which unit would be, I'll say, the better unit in 2028.
No, I heard Mr. Kearns describe the different cycles of investments, so it's like when you just make a big change in an asset, and suddenly it's almost like new, and then, time goes on, and then you do the same with the other assets. So at any point in time, either unit could be the better unit.
And in fact, with that advanced knowledge of whose unit was going to be whose, the parties could make better investment decisions. And that could lead to different results about the relative performance of the units compared to each other.
Yeah, the earlier you make that decision, then you can manage the capital program. Obviously, to the questions of capital adjustments, if you decide in 2028 I'm unit 1, you may want to decide how you want capital to be allocated between 2025 and 2028. But nevertheless, it would very much help to know which unit.
Thank you, Mr. Haynes. And regarding that split unit option also, do you recall questions from Mr. Kurtz earlier regarding what, where the coal is sourced for the Mitchell unit and those sorts of questions?
Yes.
And if the units are split, Kentucky Power, as you understand it, would have the opportunity to operate its unit.
It's possible, but it is more challenging and less cost efficient to have multiple operators of the plant, and obviously also challenging to have even more. We already have a low and a high sulfur coal pile, so it's also going to be more challenging to have even more coal supplies. Some of these things could be managed, but in terms of operators, I think it would be best to have a single operator of the site.
But even with a single operator, you generally would think that Kentucky Power would have more control over its unit than Wheeling Power's unit.
Oh, absolutely. Again, in terms of those investment and operating decisions, you could also now, we already dispatch each unit kind of as, a single unit, and the dispatch could be different as well.
And so that could give it more control over decisions such as where the coal will be sourced.
Yeah, absolutely. It could have more control over decisions.
Right. Mr. Haynes, I'd also like to ask you a few other questions related to Ms. Vincel's questions about the ELG adjustment for the
Yes.
fair market value price.
Yes.
Now, overall, do you agree, or could you comment on whether the philosophy of determining the fair market value is to value the unit historically or to value it as a going concern in the future?
Yes, the intent is that we're valuing it to the expected retirement date as of a date certain. So, but it's totally forward-looking. So you, again, use those assets that have been invested in the past, but how do they impact the costs and revenues of the operation going forward.
And so Ms. Vinsel asked you some questions about whether or not Kentucky Power is essentially paying for ELG costs as a result of that valuation. Do you recall that?
I remember a question, and I remember exactly how it was worded, yes.
Well, let me ask you, would Kentucky Power actually be paying for ELG costs, or is this just part and parcel of valuing the unit going
Yes,
forward?
if I said that it was paying for it, that wasn't my intent. The intent is, again, to ensure that as you sell something, if another party has made an investment to help increase the valuation of it, that you shouldn't get I'll call it a free ride by not reflecting in that valuation cost the other party put in. So really the adjustment, the CapEx adjustment, including ELG, is just taking out the fact that Wheeling had made greater investment over that period of time, which impacted that valuation. So they're not paying for ELG, it's just reflecting that greater than 50% share of costs.
Right, thank you, Mr. Haynes. You may recall also that Ms. Vinsel asked you about decommissioning costs also, and what
Yes.
Wheeling's responsibility would be. And as I recall, the nature of the question was, when would Wheeling be paying decommissioning costs?
Right.
And you would agree that after the sale through any sort of buyout, Wheeling Power will be operating the plant in the future.
That's right.
And it will be fully responsible in the future for all of the costs associated with that operation, and Kentucky Power will not be.
That's right. The intent of the buyout is to take Kentucky Power totally out of the operation, including out of the obligation to do the decommissioning, and is giving them with these appraised value of decommissioning, or estimate of decommissioning, the estimate of that cost, so that Kentucky would not have to be responsible at all for decommissioning.
Right, and so at that point, Kentucky Power, whether it pays for it then or not, becomes fully responsible for all of the risks and liabilities associated with that future decommissioning.
That's right.
And also responsible if whatever that deduction was from the price is not sufficient to cover any part of the costs.
Right. The expectation would be the decommissioning costs, if you were to retire in 2028 versus 2040, the cost would only escalate over time, whereas the estimate is being done as of a 2028, I'll call it assumed retirement, but we would expect that cost to be higher by 2040.
Thank you, and I think I may have misspoken. I may have said Kentucky Power.
Oh.
When I meant to imply that Wheeling Power was going to be responsible.
Oh, okay.
Do you
I
understand that?
wasn't sure if I heard you right or not.
Okay.
Okay.
Just to clarify. Thank you, Mr. Haynes. I don't have any other questions on redirect.
All right,
I have a follow-up, if that's okay?
sure.
I just want to follow up on one thing you said when you were discussing the unit split or swap, or however you want to refer to it. You made a comment about current drafting, and I know all I've seen is testimony. Is AEP putting a proposal to paper for what that might look like?
Yes, we're in process of drafting, I'll call it a new 9.6, which would say, okay, if you haven't come to an agreement on a retirement or a negotiated transaction, now you have the option for this swap transaction, and we are working on that draft. I'm not sure when it will be done, but we certainly at the right point would be providing that to folks.
Okay. That's it.
Anything further, Mr. Grosbeck?
No, Your Honor. Thank you.
All right, we'll take a recess for lunch until, we'll come back at 1:25.
No, I'm still piddling around here.
All right, great. We're back on the record in case number 2021-0022421. 421. Mr. Haynes, you're still under oath. I checked my notes. I do have a couple of questions that I'm confused about, or I don't know how they go in, and then I'll give you an opportunity, Mr. Crespo, to redirect. There have been discussions, and I've spent my lunch break trying to find them in other case records and can't. But there have been discussions in earlier cases, whether it's in the 370 investigation or the 2021-00004, the denial of the CPCN for the ELG and only approving the CPCN for the CCR, about the difference in the economics between CCR and ELG, and that the difference in the economics, of course, are partly related to, replacement generation and the cost to comply with ELG. But there was also a difference in economics between an expected retirement date in 2028 versus an expected retirement in 2040 in the way investment decisions were made, we'll call it now until 2028. Are you aware generally of that just general difference between if you're planning on retiring something versus continuing to operate it past a certain date, that you may make different investment decisions?
Yes, I am.
Okay, and is this idea around the CapEx adjustment intended to, at least to some degree, accommodate those differences in decisions?
Yes, the fact that if left to it by itself, Kentucky Power might choose to make less capital investments, or I'll call it cheaper capital investments, to an earlier date than Wheeling would on its own. And so it allows for the fact that Wheeling could go ahead and continue to make those investments, and up front, Kentucky pay less for those. But if there is only if you go to the fair market value process, then you make an adjustment for that in the price.
And what I want to make sure I understand the difference of, you're talking about the difference in it, you said more expensive, I think less expensive was the distinction you made, but if there was an investment, not ELG, but if there was an investment necessary to operate the facility past 2028,
right?
But for continuing or expecting to operate it into 2029 and beyond, they wouldn't make, but that they otherwise choose to make, right? A hypothetical may be the easiest way. I would draw that question. A hypothetical may be the easiest way for me to help me understand how this interacts with these two agreements that are proposed. If God forbid the EPA proposes some other environmental compliance requirement, and let's say that it's similar to ELG, which is like I'm really simplifying this, but it's effectively either make the investment now to continue operating for the foreseeable future, or choose not to make the investment and you have to retire by X, right?
Right.
Kind of like ELG is, or kind of like CCR, I think is maybe, or no, ELG,
Right.
Where you can not make the investment and run through the end of 2028, or choose to make the investment, but you have to put your plan to make the investment by a date certain, have it in place prior to that 2028 date. If only CCR compliance had been approved, only a CPCN for CCR had been approved for both utilities, and this compliance date is in the future, right? Then it wouldn't make sense to do this investment because there's no expected operation of the facility past December 31st, 2028, right? That's the first hypothetical. Compare that then to the counterfactual of an ELG and CCR, CPCNs were granted, and it's expected to operate through its estimated retirement date of 2040, and so it would make sense under that to make that investment. You would make that investment to keep operating. In those situations where under the Kentucky Commission's orders, where Kentucky Power, there's no economic basis to make that investment. Under the operating agreement, is it that Kentucky Power won't pay any of that cost to make those investments, and those costs will be recovered exclusively by Wheeling?
Well, under the current operating agreement, is that?
Under
you're
the
asking?
proposed operating
Oh,
agreement?
under the proposed ownership and O&M agreements. Yeah, under the proposed ownership agreement, again, that kind of expenditure, again, it's not contemplated that there's some other expenditure that's 100% Wheeling, but it certainly could be handled exactly the same way. I think the language right now, the way it reads, though, it's more likely to be a little bit of a split. And so the operating committee would have to get together and agree, hey, this expense only makes sense for Wheeling, and change that. Under the current construct, I think Kentucky would have to pay a portion, but it would be a minority portion, right, based on the formula that's there.
But why would that make sense in the reality that the Kentucky Commission only approved CCR, and that under our orders, there's an expectation, the economic expectation of our opinion was based on, or the commission's order was premised on an economic analysis of either continuing to operate through 2040 or retiring December 31, 2028, the difference between ELG and ELG and CCR, or the difference between CCR and ELG and CCR.
Right.
Then that would be, if there weren't conflicting decisions and the Kentucky PSC order controlled the entirety of Mitchell Power Plant, if that otherwise would not have that no investment would have occurred, then why should Kentucky Power be allocated a portion of costs that are otherwise in contravention of this commission's order?
Hey, I'm just looking at how the agreement is currently drafted. It certainly, there could be a provision to allow for any, I'll call, program of expenses that only are to be invested by one company should only be paid for by that one company. Right now, it's only written that applies to ELG, but that could apply to ELG and any other future compliance in the example you described. But right now, it does not really allow for that, except for this allocation of based on time to 2040, where most of the expenses would be paid by Wheeling up front.
Are you aware of the economics that I was discussing about these? I'm going to refer to them as effectively capital expenses that aren't incurred in expectation of a wind down or retirement. You're aware of the
Yeah, so you would, so
concept?
for example, you might maintain a piece of equipment rather than replace it, and those kind of expenditures.
Right. So, but if there's an expectation that the both units of Mitchell are expected to continue to operate, you don't have an expectation then that those types of decisions will be made with respect to Mitchell?
No, I would expect that the operating committee would continue to make them, but the allocation would be predominantly to Wheeling under the current draft that we have.
Okay. And how would you propose to ensure that Kentucky Power's actual economic reality reflects that case 2 that the commission approved for just the CCR investment?
Well, I think we have the construct to handle that, again, because 100% of the ELG is being paid for by Wheeling, and this technical committee will make sure, technical report that Mr. Kearns talked about will lay out exactly the clarity to make sure that Kentucky Power does not pay any of the ELG.
But that only discusses ELG. What I'm asking for
Are
are those economic decisions that were different between case 1 and case 2, given that to your point, you might fix something instead of completely replacing it, expecting it would only go 2 or 3 years instead of 15 or 20 years.
Yeah, Kentucky Power is going to continue to benefit from some of those. I think that's the challenge. It's really hard to draw a line and say that Kentucky does not benefit. So if we, again, maintained a piece of equipment instead of replacing it, Kentucky still benefits from that decision. But if you replace the equipment, it's still going to operate the plant, and Kentucky still benefits from it. It's not a clear black and white saying there is no benefit to Kentucky. It costs more, but Wheeling will bear more of the cost.
Right, but what I'm trying to ask is, you've noted that is a different economic consequence, fixing something versus investing in it. But for this half undivided interest, affiliate, ownership of a half interest, undivided interest in this facility, the commission's decision in 2021-0004 was premised on, case 2 was premised on a retirement at December 31, 2028. Forget that we're going to benefit from continuing to operate it. If the decisions that are made are more expensive exclusively to allow Wheeling to continue to operate the facility post December 31, 2028, don't you think there should be some change or some sort of acknowledgement of that in these agreements so that Kentucky Power is held harmless from the economic analysis that sort of underlaid the commission's decision?
Well, again, in Article 7, that provision where Wheeling pays a greater portion of the cost is intended, again, I don't think we used the word hold harmless in drafting it, but we are trying to do just that. Does it do it perfectly? I can't say. Maybe after the fact you could, but it is trying to put more of the cost on Wheeling because Wheeling will get the benefit after 2028.
The benefit of particular investments.
But there also will be a benefit before 2028.
What I'm asking is, there would have been a different investment. There's going to be situations where there would have been an entirely different investment if the expected retirement date was December 31, 2028, correct?
There would definitely be some different decisions. I'm not the expert, and Mr. Kearns would be better able to handle that, but there would be some different decisions.
Right, and what I'm asking, forget the allocation of what decision is made. Is there a provision in either agreement that takes into account that there would have been different decisions if only CCR only CCR upgrades had been done to Mitchell and there was a retirement date of December 31, 2028?
The only provision is Article 7 of the ownership agreement, which allows for that allocation of capital.
Okay, and does that allocation of capital have a provision, are you aware of anything in that allows for consideration of what the investment otherwise would have been, or is it just a different allocation of what the investment actually was?
It's an allocation based on the life of the asset. So again, if the life of the asset is less than 2028, both pay equally. If it's longer than 2028, that greater share will be paid by Wheeling.
Okay, so if it's a replacement of a boiler instead of fixing a boiler, the proposed operating agreement just says we're going to allocate the new boiler this way. It doesn't say we're going to allocate to Kentucky Power what would have been their share of fixing the boiler.
Correct. It does not get into that kind of detail.
And would you would agree that the commission, when it made its decision between case 1 and case 2, it didn't take this into account? Would you agree? It was either a retirement date at 2028 or a continued operation until 2040?
I guess I'm not sure I'm aware of all the things that commission took into account, but I would think that this particular capital.
Let me withdraw the question there. The economic analysis the company proposed was either premised on a 2028 retirement date or continued operation until 2040, the difference between case 1 and case 2.
Yeah, correct, yes.
Do you have any additional questions? Okay. Mr. Crespo, any questions? Any redirect?
Yes, Your Honor. Thank you. Now, Mr. Haynes, in the questions you were just asked by the chairman, I think we were focused on section Article 6, which discusses apportionment of station costs. I wanted to ask you about how Article 7 might impact that same thing. Article 7, if you want to look there, that's about the operating committee, isn't it?
Yes, it's the operation of the operating committee.
And the operating committee has the responsibility to approve a number of different things related to the operation of the plant.
Yes.
Are among those the capital budgets?
Yes.
And so in order for capital dollars to be spent on improvements of the plant, you would agree then that under the current agreement, those capital improvements have to be approved by both Kentucky Power and by Wheeling Power?
Yes.
And so, for example, let's say that there is a potential capital improvement that's not ELG. There's something wrong with the boiler, and so an investment needs to be made that will improve the efficiency of the boiler. And that's a capital investment, so Kentucky Power and Wheeling Power would have to approve that improvement.
Yes.
And not only that, improve the improvement, but also what type of improvement it would be.
That's
Whether it's
right.
Replacement of the boiler or a smaller fix to the boiler.
Right.
And so that decision of Kentucky Power, you would assume that it'd be something that'd be reviewable in future decisions by this commission.
Well, yes, so in future cases for, the rate base and the improvements made to the plant.
Yeah, thank you, Mr. Haynes. And let's assume for a moment that, that improvement, which we're hypothesizing, would go into operation after 2028. Who would pay for it then?
I think going in operation after 12/31/28 would be paid by Wheeling.
And if it went into operation before 2028, who pays for it then?
Well, again, there's an allocation is laid out in the agreement.
Right, so it's a combination of both Wheeling Power and Kentucky Power.
That's right.
And Kentucky Power, you would agree, it pays only its proportional share of the spend for, that precedes 2028.
That's right.
And maybe you could just expand on that example a little bit, because that's an example where the heat rate would be improved for the unit. Does Kentucky Power benefit from that before 2028?
Yeah, an improved heat rate would use less fuel for a given megawatt hour production and would benefit both parties.
And that, if there was to be a buyout transaction in the future, that investment by Kentucky Power, you would assume would be taken into account in whatever price was arrived at.
Yeah, and if it's the fair market value approach, it's in the formula, but we would expect it to be in any approach on a transaction.
All right, thank you, Mr. Haynes. I don't have any further questions.
Can I get a little clarification, Mr. Crespo? And maybe this is something you help with instead of the witness. Is the current operating agreement, the one that's currently in effect, is it filed as a tariff with FERC? Are you aware? Is it a rate
Yes.
schedule?
That's true. It was originally, the current operating agreement was originally filed with the FERC. That's correct.
Well, that I think that may be a legal distinction that I may ask for some briefing on, but is it filed with FERC or is it
Yeah,
on file as a tariff or rate with FERC?
yeah, I apologize, Your Honor. Those terms, I think, from a FERC perspective, are synonymous.
Okay. I think that's all I have. I appreciate Mr. Haynes. Is there any reason, Mr. Haynes? Well, I'll ask, do you mind to step down? I think we'll make significant progress this afternoon, but do you
Yeah,
mind
I'll
to
remain.
remain for the remainder
Yes.
of the day? Thank you. Thank you, Mr. Crespo. Ms. Glass, Mr. Crespo, would you like to call your next witness?
Kentucky Power calls Jason Cash.
Okay. Mr. Cash, Ms. Glass has done it to me too. Mr. Cash, will you please raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct under penalty of perjury? I do. Please have a seat. State your name and address for the record.
My name is Jason Cash. I'm employed at 1 Riverside Plaza, Columbus, Ohio, 43215.
Mr. Garcia,
Yeah, thank you, Your Honor.
please proceed.
Mr. Cash, would you please state your name and employment for the record?
My name is Jason Cash. I'm employed by American Electric Power Service Corporation. I am Director of Regulatory Accounting Services.
And what's your business address?
1 Riverside Plaza, Columbus, Ohio, 43215.
Did you submit in this case rebuttal testimony and discovery answers?
Yes, I did.
Were those prepared by you or under your supervision?
Yes, they were.
Do you have any changes or updates to provide to those discovery requests and rebuttal testimony?
No changes.
If I were to ask you the same questions today for your testimony and your discovery responses, would you provide substantially the same answers?
Yes, I would.
Your Honor, the witness is tendered for cross-examination.
Ms. Fensel, any questions?
No questions for Mr. Cash.
Mr. Kurtz?
Just one. Mr. Cash, based upon your experience with doing depreciation studies and net salvage and so forth, is there any place in the record where we have an estimate of the decommissioning costs of the two Mitchell units under the definition in the ownership agreement, which would be demolition, net, environmental remediation, et cetera?
I'm not aware of any estimates in the record, but there have been estimates prepared for the Mitchell plant.
Do you recall what the total cost of decommissioning?
I don't, not right off the top of my head, I do not.
If we were to ask you a post-hearing data request, could you provide that?
Yes.
Okay. Thank you, Chairman.
Mr. West, any questions?
No questions.
Vice Chair?
No questions.
So, Mr. Cash, you've done, gotta make sure I am. You've supported testimony in front of this commission before, right?
That is correct.
Okay. And in particular, at least in the 2017 rate case, is that correct?
Yes, that is correct.
And part of your testimony in the 2017 rate case was around depreciation rates for Big Sandy Unit 1 and the Mitchell plant, correct?
No, that's not correct. Just Big Sandy Unit 1 was the only one proposed in that case to update depreciation rates.
Well, I guess I wasn't clear about, so between direct and rebuttal, you did address the Big Sandy 1 unit depreciation rates and then Mr. Collins' proposals around the Mitchell depreciation rates.
I don't have my testimony, but
Okay, so were you aware that before that case, Kentucky Power, through its depreciation rates, recovered terminal and interim net salvage values for the Mitchell plant?
yes, that's correct.
Okay, and then after, as a result of a settlement that was adopted with, I was gonna say small modifications, but modifications in that case, the Mitchell depreciation rates no longer recover terminal net salvage. Is that your understanding?
That had occurred in the 2017 case as part of settlement, yes.
Starting in January of 18, I think, the rates for Mitchell changed, they removed terminal but kept interim. Is that your understanding?
That is my understanding, yes.
Okay. So terminal net salvage value is, as I appreciate it, is a way to recover through depreciation rates the expected decommissioning cost of a facility net of the salvage value for any of the items that are decommissioned. Is that accurate?
Correct, and just want to make one clarification too, because decommissioning costs, and I think in some of the agreements includes AROs,
Okay.
or the ash pond liabilities, and in this case, the term decommissioning costs does not include those costs.
Okay, and AROs are asset retirement obligations, is that right?
That's correct, yes.
So, and well, just take a big step back. For ash ponds, I don't know what the genesis is. The genesis, I think, of the AROs for ash ponds is similar to like what they do for nuclear facilities, right? Where you expect to have this significant risk, I guess, in the future that you're trying to recover the cost of throughout the life of the asset. Is that a fair characterization?
It's somewhat similar. It's just to recognize that there is a liability, a legal liability on the books.
Okay, that's as good of a characterization as I can make, having not done particularly well in accounting. So, so you had depreciation rates that have attempted to recover some amount for decommissioning of Mitchell over the years, through a number of years, at least up to January of 2018. Is that what we've agreed to?
That's correct, yes.
Okay, and I remember in the sense that I looked it up, that Mr. Collin, let me know if you remember this, in that case, Mr. Collin proposed to remove terminal net salvage value, change the depreciation rates for Mitchell to remove the terminal net salvage for, well, so let me take a step back, let me withdraw that. A couple proposals to change the revenue requirement in that case. The first was to reduce the depreciation expense by removing terminal net salvage for Big Sandy 1. I think that was your point, that your direct testimony was supporting increasing the depreciation rates from what they were at the time to start recovering a negative terminal salvage value to reflect in those depreciation rates. Is that right?
The proposal in that case, the original proposal in my direct testimony was with Big Sandy Unit 1 with of course, a component for terminal net salvage, yes.
Okay. And the rates already had, depreciation rates already had net terminal salvage value for Mitchell, and is it your memory that Mr. Collin proposed also removing those?
Again, I don't recall, but I mean, that doesn't surprise me with the settlement that was made in that case, yes.
Okay, so can I ask can we provide a copy of this? Can I pass these out? I don't want to pass them out, but can I hand these to you, Ms. Venzel, and you provide Mr. Cash one and Mr. Kurtz one, and I'll get one too. There's the rest of them. Actually, here, you can have this one as well.
Yeah, approach the witness.
Yeah, please. I've sort of directed you to at this point, so.
Want to make very careful about it. Thanks.
Thank you.
We'll get one to you. So do you have a copy of that now? Mr. Collin usually does a table on about page 5, maybe. I'm gonna pull it up here, where he calculates the revenue requirement impact of his adjustments. Do you have that in front of you?
Yeah, it's page 4, is that?
That's
the
right.
Bottom of page 4.
Yeah, and so that is his testimony. What I've handed you is his testimony from 2017, 179, direct testimony on behalf of the KIUC, where he noted what the revenue requirement adjustment would be for removing terminal net salvage for the Mitchell plant. Do you see that? I think it's like something like $570,000 maybe.
Yes.
Okay.
I see it.
So, in this record, do we have the amount of accumulated depreciation as a result of exclusively the terminal net salvage value recovered for Mitchell?
In this case, we have an amount, so for gap reporting, we have to record a regulatory liability for all salvage costs, interim and terminal. In this case, we have an amount that includes both. We don't have it separated out by what's interim and what's terminal.
And that's why when you say both, you're making a distinction between interim salvage, interim net salvage, and terminal net salvage, correct?
Correct.
So do you know what a portion what those amounts are relative to each other each year for rate-making purposes?
I don't.
Okay, so.
Because, and the reason why I don't is because typically we just add a net salvage percentage to the depreciation rates, or I guess to the, as like an adder to the original cost, and then that becomes a component of the calculation. So I guess I don't have it broken out specifically. This is interim, this is, but I could go back to my records to see what those amounts were at the time, or those percentages were at the time.
I guess, taking a big step back, you and Mr. Haynes you gave him some of the information that he made operative testimony about, but a lot of it was based off your testimony too, in response to, in this case, Mr. Collins' direct or intervener testimony. Kentucky Power customers have already paid money, some portion of money, whether it's minuscule or significant, but some amount of money to decommission the Mitchell Power Plant. Would you agree?
I would say that they've paid some amount, but at the same time, you know, the net book value of the plant has not been fully depreciated either. So it's hard to say how much of that has been, I mean, we do have to break that out for gap reporting, but at the same time, when the full value of the plant hasn't been depreciated, it's hard to say that that this amount is related to net salvage, this amount's related to what we call the life rate, just because you're still in a position where the plant hasn't been fully depreciated.
Well, if Kentucky Power does sell the Mitchell Power Plant, whether it's tomorrow, in 2028, beyond, whether to an affiliate or a non-affiliate, don't you think it's appropriate to account for the amount if Kentucky Power customers are going to be on the hook for decommissioning when somebody else owns it and they decommission it? Don't you think it's appropriate to take into account the amount that Kentucky Power customers have already paid for that task?
Yes, and I think that will flush out at the end in the sense that right now I totally agree that there's an amount on the books that relates to net salvage, and Kentucky customers have paid for that. But until you get that, if we're talking when the demolition or the decommissioning happens, until you get that final bill, that would be whatever that additional cost was would also be added to any other undepreciated balance that we have on the books at that point in time.
But if it's transferred at net book value, we're not talking about an undepreciated balance at that point, right? It's going to be transferred. It'll be wiped to zero at that point, correct?
At what point?
If it's sold and it's sold at net book value, right, there will be no remaining undepreciated value on the facility on Kentucky Power's books, right?
Only if it's sold at net book value.
Right. That was the question. If it's sold at net book value,
If it's sold at net
that's
book
the case.
value, correct.
Okay. And if it's sold in excess of net book value?
Well, if it's sold at excess of net book value, would that be part to cover those decommissioning costs?
I'm asking how it's taken into account. So I'm asking how the company proposes to take into account for a number of, let me take a step back. It seems like the company, Kentucky Power, APSC, they're only taking the amount that, considering taking into the amount that Kentucky Power customers have already paid for decommissioning, only in the event that this fair market value backstop occurs. Is that your understanding?
I don't know if that's true or not.
Okay. So has the company asked you to attempt to try to the best of your abilities, pull out what the amount that customers have paid for terminal net salvage value has been since Mitchell was approved for transfer to
No,
Kentucky Power?
other than what we have on the books for the total net salvage, not including terminal and interim.
So what are you going to have to do to be able to try to estimate that amount for terminal net salvage value?
I'd probably have to go back and look and see what the change in depreciation was at that point in time and assume that is the amount that Kentucky Power has, that was the decrease in depreciation expense as a result of terminal net salvage being removed.
Okay. And that'd be in the neighborhood of that adjustment that Mr. Collin proposed. Assuming Mr. Collin calculated it correctly, that would be what you'd effectively be taking, the amount that would be in rates and trying to back that out of the total salvage value. Is that what you're kind of saying?
Yeah, I mean, I don't want to verify the calculation, but I mean, I guess it would be some amount similar to that, assuming this calculation is correct.
And I guess what I'm really asking, forget Mr. Collins' testimony for a second, but you would take the revenue requirement difference that was reflected in that settlement, for instance, that you all had, that you removed net salvage value from Mitchell. So you think you can take that and back it out of the annual depreciation expense related to net salvage to get in the neighborhood of what that terminal net salvage was in relation to the interim net salvage?
I mean, it would be an exercise, it would be probably an estimate, but I mean, I guess we could go through some sort of exercise to get that. I would just want to make sure I have all the facts and circumstances.
Well, it would appear to me that at least compared to everybody in this room, including myself and Mr. Overstreet, that you're probably the best person, you're the best qualified person to do that. I'm with Mr. Overstreet on occasion. I did go to law school, so I could do a little bit less math, and here we are. So you're the person that could do it. You're the one that has the books available to you to do that, correct?
Correct.
Okay. And so if we ask that as a post-hearing data request, do you think that's something that you could turn around in a couple of weeks, or that you would need additional time?
No, I think that would be fair in a couple weeks.
I think we'll ask as a post-hearing data request to try to get out what amount of that terminal net salvage that was I don't want to say recovered from customers, but maybe we ask it a couple ways, actually realized about the company and then also recover from customers, because that may be a distinction in when the transfer occurred versus when the rates were changed, reflecting that.
And to be
terminal
clear,
established.
you're asking for the period up till 2018?
It would be from-
When Kentucky purchased the unit?
That's right. That's right. And then the other side of it is, we've talked today that Kentucky Power purchased its undivided 50%, it's 50% undivided interest in Mitchell at net book value. Have you heard that?
Yes.
Okay. And do you know when it was an asset of Ohio Power Company, whether Ohio Power Company recovered terminal net salvage value for the Mitchell units?
I don't know that, but I would fully expect them to recover some sort of terminal net salvage, yeah.
Okay. And do you know how that will be taken into account, or is being proposed to be taken into account?
I do not.
Do you think it should be taken into account?
I think it was taken into account when the sale was made at net book value.
Okay. You mean in determining just the fact that it was part of accumulated depreciation as an offset to original
That's correct.
cost? Okay. All right, I appreciate it. I think that's all the questions I have for you, Mr. Cash. Thank you.
Chairman, can I ask one question based upon an answer before redirect? Or I can wait till redirect?
No, that's fine. If that's, yeah, we'll do that.
Okay, thank you. Mr. Cash, did I understand you to say that the definition of decommissioning does not include the ARO ash pond remediation requirement?
No, I'm saying that I think because the word has been used in different instances, I think in the agreement, and I may be wrong, but I think in the agreement, decommissioning costs do include those. But in the sense that myself and the commissioner were talking, I was speaking exclusively without those AROs being included.
Okay, because the definition of decommissioning does include removal or remediation of any hazardous materials or other contaminated equipment, materials, coal ash, or waste associated therewith in a manner that meets the requirements of applicable law. So that would include ash pond remediation in the definition of decommissioning?
And I think you read from the agreement?
Yes.
And so, yes, I mean, that is inclusive of that. But again, that's why I just wanted to be clear on the record that the decommissioning cost I was speaking of was exclusive, or did not include the ARO cost.
Okay, thank you for the clarification. Thank you, Chairman.
Mr. Garcia?
Yeah.
Can you redirect?
Yeah, thank you, Your Honor. And just to clarify, and I think that there is record on this already, but in a fair market value transaction in which Kentucky Power sells its interest in Mitchell to Wheeling under the proposed ownership agreement, that transaction would extinguish all of the liabilities and costs that Kentucky Power would otherwise be responsible at the time that the Mitchell unit were to be physically retired. Is that correct?
That's my understanding, yes.
Okay. Mr. Cash, you were asked some questions about the 2017 rate case and the depreciation rates for Mitchell and Big Sandy 1. And let me ask you a preliminary question. How are depreciation rates calculated for regulatory purposes? Let me start there.
We take the original cost plus a component for net salvage, less the accumulated depreciation, and then determine a rate that is recoverable over the remaining life of that particular asset.
And when you talk about the remaining life, what is that under the ruling from the commission as to the CRE and ELG projects, in which it was determined that Kentucky Power was only going to approve, engage in the construction of CCR equipment and not ELG? What would be that date?
2028.
Okay, so under what you are telling me, then the remaining life of the interest in Kentucky Power would be up to 2028, and then the net book value would be depreciated from whatever it is today to zero?
Yeah, we would propose that, but then those rates would be subject to approval by this commission. And, it doesn't necessarily have to reflect a net book value of zero, but that would be the proposal, yes.
Now, are you aware of situations in which, through rate-making processes, a mechanism is set up so that in a situation in which a unit needs to be retired sooner than the depreciation rates were calculated for, that there is some mechanism to alleviate the pressure on rates, that it's necessitated by depreciating the remaining book value over the life of the asset?
Again, if approved, a regulatory asset could be set up for a situation like that, where the rates don't reflect the actual retirement date. The approved depreciation rates don't reflect the retirement date of the plan itself or the asset.
Are you aware of that being the case, for example, with the net book value of Big Sandy 2 relative to when it was retired?
I think that's exactly what happened with Big Sandy Unit 2, is the plant retired and then a regulatory asset was set up.
And a more recent example would be the Perky plant?
Yeah, the Perky plant, it's been announced as 2023, but however, there's still some regulatory proceedings going on. At this point, we simply have a regulatory asset for GAAP presentations or financial reporting presentations. So there is a regulatory versus financial reporting difference, or GAAP difference.
No further questions, Your Honor.
Thank you, Mr. Garcia. Is there any reason Mr. Cash can't be excused?
No reason, and staff would also move to include staff hearing exhibit number 3 into the record.
And that would be Mr. Collins.
Mr. Collins' testimony for
Testimony.
case number 2017-179.
And for the benefit of the parties, we will make sure that before the end of this hearing, probably in the next few minutes, we'll provide everybody an electronic copy of that testimony in its entirety. I think all that was provided to the witness was the written testimony in his affidavit and not the 70 pages of exhibits, because we were trying to save a little bit. I was trying to save a little bit of ink. Did the company have an objection to the introduction of that?
Your Honor, it would seem appropriate to the extent that we're going to use this as an exhibit to limit it to the pages that were presented to the witness and that were the subject of the examination.
That's fine. I was thinking that you all may want the entire document so that you have anything else in it that you would like to note if there's discrepancies or issues or miscalculations. But I'm happy to limit it to what was provided, but I just wanted to make sure that I didn't give the entire document so that you didn't have the entire document to use for the remainder of the hearing.
Your Honor, to your discretion, introducing it completely would be fine, but this is testimony in a different case, and it's only for the value of the fact that it was presented in that case.
Okay, that's fine. That's fine to limit to the first, to the actual testimony portion of his affidavit. That'd be fine.
Just a second, Your Honor. Yeah, that would be fine, Your Honor.
Okay.
Thank you.
Thank you, Mr. Cash. I appreciate it.
Thank you.
We're going to have to come to some sort of decision on that one of these days, because some of these testimonies that we get or some of these documents we get are 3,000 pages, and somebody wants to print off one page and hand it out as an exhibit. That's not very helpful to opposing counsel, who would then like to ask some redirect on the subject. So I appreciate you bringing it up. All right, Mr. Garcia, Ms. Glass, Mr. Overstreet, do you all have additional witnesses?
Yes, Your Honor, Kentucky Power calls Allison Keaton.
Keaton, thank you.
Yes.
Ms. Keaton, please raise your right hand. Do you swear or affirm the testimony you're about to provide is true and accurate, true and correct under penalty of perjury? Please have a seat. Please state your name and address for the record.
My name is Allison Keaton, and I'm at 1 Riverside Plaza, Columbus, Ohio, 43215.
Mr. Garcia, you may ask.
Thank you, Your Honor. And by whom are you employed?
I'm employed by American Electric Power Service Corporation.
In what capacity?
I'm a tax analyst, principal for tax accounting and regulatory services.
In this case, Ms. Keaton, did you provide rebuttal testimony and discovery answers?
Yes, I did.
Do you have any corrections or updates to your rebuttal testimony or those discovery answers?
No, I do not.
If I were to ask you the same questions that were asked in your rebuttal testimony and your discovery answers, would you provide substantially the same answers today?
Yes, I would.
Yeah. And these were prepared by you and under your supervision, correct?
Yes, correct.
Your Honor, the witness is standard for cross-examination.
Ms. Vincent, any questions for the witness?
No questions for Ms. Keaton.
Mr. Kurtz?
No questions.
Mr. West?
No questions.
Vice Chair?
No questions.
Let me check my notes, Ms. Keaton. And excuse my ignorance. So, you were at least partially related or participated in the 2021-00004 case, is that right? Which was the request for a CPCN for CCR and ELG?
I was not.
I was not. So have you looked at that testimony at all where Mr. Collin talked about the tax impairment of the retirement of Mitchell? Or the tax consequences of the retirement of the generating unit?
I am aware that he talked about an abandonment loss. Is that what you're referring to?
That it is.
Yes.
And have you reviewed that testimony about the abandonment loss?
A little, yes.
Okay. And I guess what I'm wanting to understand is, looking at counterfactuals of keeping Kentucky Power not selling Mitchell versus selling Mitchell.
Okay.
Is that abandonment loss available as a quote benefit, as an offset to rates, or something that can be taken into account to reduce rates? Is that available if Kentucky Power maintains ownership of Mitchell at the time of its retirement?
If under Code Section 165, the abandonment loss, you have to have an intent to abandon, and you also have to have overt cause, and one of the examples of that is the failure to sell, and in the current case, we have a willing buyer of Wheeling Power, and so that kind of blows the abandonment loss out of the water for this situation. But for the CCR and ELG, there wasn't a willing buyer, so it's a possibility that there could have been abandonment loss in that situation.
Right, and so I just want to make sure, taking a big step back, the distinction that you're making in your response is the commission had a decision in front of it here. We had a decision, CCR ELG 2028-2040, or expected 2040, estimated 2040.
Okay.
And at 2028, that abandonment loss was on the table in the sense that it could have been a deduction available in the event the retirement actually occurred in 2028. Is that accurate?
If there wasn't a willing buyer, and there was intent for abandonment.
Okay, but the fact that Wheeling intends on operating the facility through 2040 and investing in CCR and ELG, even if that was a qualitative, something that was in the back of the commission's mind in approving the CCR only, that's off the table because they intend on operating through 2040. Is that correct?
That's correct.
All right, I really appreciate it. Thank you, Ms. Keaton.
Okay, thank you.
Do you have any redirect, Mr. Garcia?
I don't, Your Honor.
Okay, great.
Your Honor, I'm sorry.
No, go. No, this perfect time.
Okay, before we move to the next witness or whatever you're looking at your watch for, given the fact that Mr. Cash referred to his rebuttal testimony in 2017-00179, the 2017 rate case.
Right.
Could Kentucky Power would like to request the commission take administrative notice of that rebuttal testimony.
Any objection? That's fine.
Thank you, Your Honor.
That's fine. And in fact, we can take administrative notice of it. I would prefer if we get a copy of his rebuttal testimony and we can just add it as an exhibit to this case so that it's something that's already in the matter and it's referenced and somebody doesn't have to go 4 hours into a hearing to find out that we had accepted it on, we had adopted it by administrative notice. So if today or tomorrow we can get a copy of that to provide in the order, we'll make sure that we mark that as Kentucky Power hearing exhibit number 2.
Right. And so do I need to, with that, do I need to move its admission, or is that already taken care of?
Over everyone's objection or not, or otherwise, we'll take care of it.
Thank you, Your Honor.
That's my fault for introducing it then. All right. Thank you very much, Ms. Keating. You may step down. So I just want to, as a housekeeping matter, and it was a text message, not something to do, so it's just having that a look. I want to make sure that we take a minute here for housekeeping for me. I have that we have staff here exhibits 1, 2, and 3, with one being, let me get them here, because I have them marked. Staff hearing exhibit 1 is the data request PSC 1-8. Staff PSC staff exhibit 2 is the Excel spreadsheet PSC staff 1-16, the Excel attachment. And then 3 is Mr. Collins' testimony from the 2017 rate case, 2017-179. Is that correct?
That's correct.
Okay. And then KIUC Exhibit 1, hearing Exhibit 1 is, is the filing that has been made or made at once or over the years in 2012, 578, those 5 years of Mitchell operating numbers?
Yes.
Is that correct? Okay. And then Kentucky Power 1 is the amended exhibit to Mr. Haynes' testimony that was filed today. And then 2 will be the rebuttal testimony of Mr. Cash in the 2017 rate case?
Correct.
That's correct. And just to make sure we've got that right, the first exhibit is a correction to a response to a data request.
Okay, all right. But it was refiled, the correction was filed today, right? This morning? Okay. All right. Thank you for indulging me. I don't want to make a mistake here. All right, Mr. Garcia, Ms. Glass, would you like to call your next witness?
Yes, Kentucky Power calls Brian West.
Okay, Mr. West, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Brian West, 1645 Winchester at, I can't believe I just forgot whether it was a street or an avenue.
I've seen it enough, it's Avenue.
Yeah, Ashland, Kentucky, 41101.
Okay. Ms. Glass, you may ask.
Thank you. Mr. West, can you please state your employer and your position?
Yes, my employer is Kentucky Power Company, and I'm the Vice President of Regulatory and Finance.
And did you cause to be filed into the record of this case responses to data requests?
Yes, I did.
And do you have any changes or updates to those responses?
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
And can you please confirm that you did not file testimony in this case?
That is correct, I did not.
Thank you. The witness is available for cross-examination.
Ms. Vincel, do you have any questions for the witness?
Staff has no questions for Mr. West.
Mr. Kurtz, any questions for Mr. West?
No questions, Your Honor.
Mr. West?
No questions.
Vice Chair?
No questions.
I do have a couple questions following up on Mr. Madison's responses to me earlier about how you and he were effectively the two individuals from Kentucky Power that were employed by Kentucky Power that were involved in the negotiations or the conversations around the Mitchell agreements. Were you in the hearing room for those questions and responses?
I was in the conference room listening.
Okay.
Yes.
But you had availability to listen in
Yes,
real
sir.
time to the, okay.
Yes, sir.
So can you explain your input, what your role was in coming up with the idea or the framework, I think it's been referred to earlier, of the Mitchell ownership agreement?
I did not have any direct involvement in coming up with it. My involvement on the operating committee is to be Mr. Madison's alternate, should he not be available to attend a meeting or something. That's primarily my role on the operating committee.
Okay, and so while you were filling the role as Mr. Madison's alternate, did you take part in any of the discussions that led to the creation of the ownership agreement?
I did not, sir.
Okay. All right. Thank you very much, Mr. West. Can you redirect this class?
Yes, sir.
Thank you for being here with us. You may step down. Ms. Glass, would you like to call an additional witness?
Yes, Kentucky Power calls Alex Vaughn, who is appearing remotely.
Okay. All right, Mr. Vaughn, you weren't here earlier, so I'll give you the introduction on this is that, well, you're not in a room with several other people. Oh, that if you are in a room, please shut the door so that outside noise does not interfere. If you have wired headphones or a phone instead of computer audio, that's preferred. And that we ask that you alert us through whatever contact information you can, Mr. Vaughn, if you are disconnected or you experience any technology failure while providing testimony today. Can you hear us?
Yes, I can. Can you hear me?
I can hear you. I can't see you, though.
I know. I can see myself in the settings bar here, but the camera is grayed out.
Okay.
It's telling me it says turn on camera, but there's a little slash to the camera as well. It sees my camera.
So we've had this happen before. It's been a while. So if Mr. Vaughn can't get this camera to work, at this point, I know what Mr. Vaughn's voice sounds like. This is usually the time of day in which he subjects himself to cross-examination, because I think he's the last witness you've called. And we've fixed this in the past when somebody doesn't appear on camera, that instead of dealing with the technology for minutes or hours on end, that I just ask that after the hearing, that you all have Mr. Vaughn file a affidavit stating that it was him that appeared via video or, via audio today, and just as long as it's verified, that'd be fine. You all will follow up in the next few days with that.
Yes, we will.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Vaughn, can you please raise your right hand? And that
It is raised.
include that in the verification.
Yes.
Raise your hand. Already forgot what I'm supposed to say. Do you swear or affirm that the testimony you're about to give today is true and correct under penalty of perjury?
I do.
Okay. Please state your name and business address for the record.
My name is Alex E. Vaughn. My business address is 1 Riverside Plaza, Columbus, Ohio, 43215.
Okay. Ms. Blinn, you may ask.
Thank you, Your Honor. Good afternoon, Mr. Vaughn. Will you please state your employer and position?
Good afternoon. I'm employed by American Electric Power Service Corporation as the Director of Regulated Pricing and Renewables.
And did you cause responses to data requests to be filed in the record of this case?
I did, yes.
Do you have any corrections or changes to those responses at this time?
I do not.
If I were to ask you those questions today, would your answers be the same?
Yes, they would be.
Thank you, Mr. Vaughn. Your Honor, Mr. Vaughn's available for cross-examination.
Ms. Vincent, any questions for Mr. Vaughn?
Staff does not have any questions for Mr. Vaughn.
Mr. Kurtz?
No questions.
Mr. West?
No questions.
Vice Chair?
No questions.
So I have a few, Mr. Vaughn, and they're follow-ups from my questions, if you've been able to watch today. The questions that I asked Mr. Kearns, were you able to hear his responses to a few of my questions?
Yes, I've watched the hearing today.
Okay, and you heard, and I don't know if you have the exhibit available to you, did you hear Mr. Kurtz's questions to Mr. Kearns about generally the forced outage, E4, equivalent forced outage, equivalent availability factor, net capacity factor, and net heat rates of Mitchell Unit 1 and 2, Mitchell Units 1 and 2 from 2017 through 2021?
I don't have the document in front of me, but I do recall the discussion, yes.
Okay, and I won't ask you anything specific about the document, but you heard Mr. Kearns answer questions about that there was an equivalent forced outage rate in excess of 0. Was that your understanding of the testimony?
Yes.
Okay. And the Mitchell units are included along with, the Mitchell units are included in the FRR plan that Kentucky Power participates in PJM under. Is that right?
Yes, that's correct.
Okay. And is it your understanding that in the event an FRR plan, or say specifically the FRR plan that Kentucky Power operates under, in the event that a self-supply utility or group of utilities has capacity in excess of what they're required to on a UCAP basis in their FRR plan, that they're able to monetize that excess capacity?
Yes, with certain, there's certain restrictions on that in the PJM tariff, but there is a way to monetize that in some of the PJM RPM auctions if you do have excess length over your required reserve margin in the FRR plan.
Okay. And when you say limitations, is one of those limitations like a long short test?
Well, there's this doesn't come into account as much anymore, but there's a cap on how much an FRR entity can sell into the base residual auction, and there is a holdback amount that applies in the base residual auction as well. Neither of those apply to my understanding in the incremental auctions.
Okay. Is the FRR plan that Kentucky Power operates, has it met its maximum amount long capacity? I mean, is it to the point where it can't monetize that capacity in the BRAs?
No, that's not a problem.
Okay. So in the event that the equivalent forced outage rate continues to lower a unit's UCAP, for purposes of the FRR plan, if they had adequate capacity for the FRR plan, for every megawatt of UCAP that the equivalent forced outage rate reduces the unit's D-rate value, that's one less megawatt that can be monetized. Would you agree?
All other things being equal, yes. I mean, if you have less resources, you can make fewer sales, or you have to procure more capacity to cure a short position. But there's load, and there's other things in that equation that factor into ultimately how any capacity is disposed in a delivery year.
In addition to the equivalent forced outage rate having an interaction with the ability to monetize a unit's participation in the capacity markets, or at least the BRA and PJM, would you agree that a self-supply utility that operates in a wholesale market, the marginal cost of their own generation, assuming it's available, is effectively a hedge on higher market prices?
Can you restate the question, please?
Sure. So it may be easier to ask it in a couple of sentences instead of just trying to go for the win. So a generator, especially a thermal generating unit, has a marginal cost of producing electricity, right?
From an energy standpoint, yes, there's a incremental cost to each megawatt hour produced.
Okay, and assuming that the unit is turned over to the RTO for dispatch, when costs start to rise and it meets that unit's dispatch, that unit's marginal cost, as a general matter, the RTO dispatches that unit as the next available economic unit. Is that a fair characterization?
Yeah, under normal course of business, right? There's other reasons they could dispatch it out of economic merit order, but the premise is correct. As the system energy cost rises, more, the next increment of available generation is, dispatched in PJM.
And assuming a self-supply entity owns that generation, and the amount of generation that self-supply entity owns is adequate enough to serve its own needs, it could be expected that the costs and revenues associated with prices higher than all of its units' marginal costs, that those will offset to the point to where the LSE or the utility will effectively not pay more in the aggregate than its own generating unit's marginal cost of electricity. Is that correct?
Yeah, that's correct. And I think you have to divorce the energy and capacity markets, right? Because they really don't interplay unless, besides having a mandated offer, if you are a capacity resource. But yeah, when you're looking at an energy, purely from an energy standpoint, I think what you're saying is having a physical asset is a hedge on market prices, and that's correct. So every, but for that unit, if your unit can produce at 25 and the system energy price is 40, you are recovering your variable costs of 25, and you're making a contribution to your embedded costs of everything above that, which benefits your ratepayers.
So I want to ask about how the equivalent forced outage rate or a equivalent forced outage or even an availability rate plays into that. Would you agree that if a unit is only, if two units are identical, both owned by self-supply entities, that if one unit is only available half the time as the other and they have the same marginal cost, that one is a more effective hedge than the other in the event that the more effective unit is available to hedge more often than the unavailable unit?
It certainly is available under that scenario more often, but again, whether it's actually a hedge or not depends upon what the system energy price is and whether that unit would have been dispatched while it was forced out or not.
Right. And what is the effect of having, as a self-supply entity, what is the effect of having generation that's not available during high market price time periods?
Well, again, you have to divorce the capacity side from the energy side, because the settlement works, the energy settlement works the same either way, whether you're a self-supply entity or you're RPM or you don't own any resources, you pay somebody else for capacity or whatever. Any LSE buys all of its load out of the PJM hourly markets, and it sells into those same markets any resources it owns, it contracts for, trades, whatever. The net of those things end up being your cost of energy to your retail ratepayers. And I guess under our construct here, right, we sell in our resources, we buy out our load. Let's say they match up in an hour. Ratepayers in that instance then end up paying the actual incurred cost of fuel and purchase power that netted those wholesale transactions to zero. So again, if that's kind of the premise there. So if something's less available or more available, it could definitely affect that wholesale settlement. Again, depending upon whether it would have been dispatched or not.
Generally, how's that wholesale settlement recover from customers?
The energy settlement?
That's correct.
So that is a function of in Kentucky, that would be a function of the company's FAC, in that, like I just said, market purchases, less market sales, and, in that instance where it all nets to zero in an hour, they're going to pay the fuel cost. If a company doesn't have enough generation or resources to supply its load requirements in an hour, it is going to be a net purchaser, and the FAC cost in that instance would be some mix of internal fuel cost and market energy purchases.
All right, I appreciate it, Mr. Vaughn. Ms. Blend, do you have any redirect to Mr. Vaughn?
No, Your Honor. Thank you.
All right, thank you, Mr. Vaughn. You may be excused.
Thank you.
Does the company have any additional witnesses?
No, Your Honor.
Anything else that you'd like to take up before we move on from your case?
I believe we've had Kentucky Power Exhibit 2 admitted, but I'm not sure we've had Kentucky Power Hearing Exhibit 1 admitted. I'd like to move for its admission now.
Is there any objection?
None. Thank you.
So we'll admit Kentucky Power Hearing Exhibit 1, which is that March 1st corrected response, Mr. Haynes, correct?
Correct.
All right. Thank you, Ms. Blend.
Thank you, Your Honor.
With that, are there any Kentucky Power witnesses that we'd like to excuse from the remainder of the hearing?
I think probably all but Mr. Madison, in case we need to recall him.
Yeah, so at this point, unless the vice chair has any concern, I'd like to ask that Mr. Haynes and Mr. Madison stay around, but that all the other Kentucky Power witnesses can be excused from the remainder of the hearing if they'd like to leave.
Thank you, Your Honor. Thank you.
All right, Mr. Kurtz, Mr. West, do you have to call your witness?
Thank you, Your Honor. I'll put Mr. Collin on.
Mr. Collin, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Okay, please have a seat. State your name and business address for the record.
My name is Lane Collin. I'm a vice president and principal with the firm of J. Kennedy and Associates Incorporated.
And your business address?
Oh, I'm sorry, 570 Colonial Park Drive, Suite 305, Roswell, Georgia 30075.
Mr. Kurtz?
Thank you, Your Honor. Mr. Collin, you are testifying on behalf of whom?
Two parties, the Office of the Attorney General, and also Kentucky Industrial Utility Customers.
You have in front of you a document titled Direct Testimony and Exhibits of Lane Collin.
Yes.
Was this prepared by you or under your direct supervision?
Yes.
If I were to ask you the same questions, would your answers be the same?
Yes, they would, with the exception of certain errata that corrected a portion of my testimony that has been pre-filed.
Yeah, why don't you go over that real quick, the errata?
I think
it's on
I may have
page
left it in my
26.
briefcase.
It's
It's
on
been
pa-
filed already, but it addresses the depreciation rates and the accumulated depreciation, and it introduces the word prior to clarify my testimony on those points.
Okay, page 26, lines, whatever, what are the changes?
Oh, I'm sorry, I just found it, yes. Page 26, line 15. Between the words companies and Mitchell plant, I inserted the words prior requested. And then on line 16, the 2.5% is 2.35%.
Are those the extent of your corrections?
No, there's a few more. Page 27,
Okay.
line 12. the phrase company's Mitchell plant be after company's prior requested, insert those two words. And those are the corrections.
Thank you, Mr. Collins. Your Honor, I tender the witness for cross.
Just so I get clarification, Mr. Kurtz, are those corrections already filed in the record?
Yes.
Okay. And that was the February 10th notice of errata, all the ones that Mr. Collins just went through are in that filing, is that correct?
Yes.
Okay, all right. Thank you. Ms. Fensel, any questions, Mr. Collins?
Yes, just a few. Thank you. Good afternoon, Mr. Collin.
Good afternoon.
Can you confirm that if the buyout price is based on net book value, that excluding the ELG cost will ensure that Wheeling's ELG investment will not be included in the purchase price?
I can confirm that, that's true, but if I could just offer a little bit more explanation.
Yes, please.
Each one of the companies, Kentucky Power Company and Wheeling Power Company, have their own plant costs on their own books. And so if we use the Kentucky Power Company net book value, it by definition will exclude the ELG costs. No allocation is necessary.
And can you explain whether removing back up, if the commission were to approve a fair market value, that removing the net book value of ELG from the fair market value of Mitchell mixes methodologies for the valuation?
I did not address that, but in a sense I would agree with that, because on the one hand you have a fair market determination based upon 3 appraisals, and then you're subtracting a net book value cost of the ELG assets.
Staff has nothing further for Mr. Collin.
Ms. Glass, Mr. Overstreet?
I believe that's me, Your Honor. No longer the potted plant. Good afternoon, Mr. Collins.
Good afternoon, Mr.
You have in
Overstreet.
front of you, sir, your response to staff 3-1. If not, I can provide you with it. Your counsel can.
Well, I thought it was so very well organized, but if you do have a copy, I would appreciate it.
Surely. If you don't mind.
Actually, Mr. Overstreet, I just found it.
Okay,
so.
thank you. In that data request, you were asked by staff to, well, let me just read the request. Refer to the direct testimony of Lane Collin testimony, page 8, lines 15 to 18. Explain why the Mitchell Generating Station, Mitchell, would qualify as a product under KRS 278.2207. And that, did I read that correctly?
Yes, you did.
Okay. And KRS 278.2207, that's the affiliated transaction asymmetrical pricing guidelines.
I think that's a fair characterization, yes.
Okay. And in response, you provided the commission with a discussion of 3 commission decisions.
Yes, that's correct.
Okay. And the first one was the Kentucky Power Grid Assurance decision.
Correct.
And the second one was a 2008 Duke Energy case decision.
Yes, correct.
And then the third one was the Frontier Gas Alternative Rate Adjustment case decision.
Correct.
And you would agree, would you not, sir, that none of those cases involve the sale or transfer between affiliates of an electric generating station such as Mitchell?
Yes.
And with respect to the Frontier Gas decision, Your Honor, may I approach the witness?
Proceed.
Approach the bench.
You may. Thank you.
Have you had an opportunity, I realize you looked at it before you wrote your data request response, but have you had an opportunity today to refresh your memory of that decision?
I just quickly skimmed it.
Okay. Could I direct your attention to page 3, please?
Yes.
And do you remember, before I ask you about the text on page 3, do you remember how this question came up in this Frontier Gas decision of the applicability of the affiliate transaction statute?
If I recall correctly, there was a change in the ownership.
No, I'm sorry, that's the reason I asked you the question. It actually, well, it might have, yes. Okay, I see where you're going. It grew out of would you agree, it grew out of a rate case filed by Frontier Gas?
That's my understanding.
And the Attorney General, or Attorney General's office had concerns about owners or potential owners selling services, Frontier Gas selling services to Frontier Gas. Do you remember that?
Yes.
Okay. And
that's contained in the recitation here within the order.
yes, exactly. And then on page 3, at the top, the sentence, it's the first sentence on page 3. It says, IGS is owned by Robert Oxford. Do you see that?
Yes.
Could you read into the record, please, the remainder of that paragraph?
Yes. IGS is owned by Robert Oxford. The commission agrees that the change in ownership of Kentucky Frontier eliminated the potential for applicability of the affiliate transaction rules to the relationship between Kentucky Frontier and IGS because the entities are no longer affiliates as defined by KRS 278.01018. IGS is controlled by Robert Oxford, and Mr. Shute has no ownership in this corporation. Because there is no longer any potential control of Kentucky Frontier by IGS or Robert Oxford, as defined by KRS 278.01019, the commission finds that the motion to dismiss should be granted as to IGS.
Thank you. And you're aware of the joint application pending for the commission in 2021-00481 for transfer of Kentucky Power to Liberty?
Yes.
Okay. And you would agree that if the commission were to grant that application, that AEP and its subsidiary, Wheeling, would no longer be an affiliate of Kentucky Power?
Yes, that's right, and I addressed that in my testimony. Yes. I mean, that's just a factual matter.
Yeah. Okay. If I look at my notes, Your Honor, may I look at my notes? I know I can, but may I?
Sure. Are we going to move, this is I'm conflicted from this case, so I was just going to ask, are you moving on from Frontier, or do you have additional questions?
I'm moving on from
Okay.
Frontier.
I feel like I have to know, you sound like my first grade teacher with the can or may discussion, but I'm having
My
flashbacks.
fourth grade teacher was Naomi McCracken, and she was a Pentecostalist lay preacher, and I learned a lot. I don't think I have anything else, Mr. Chairman. Thank you.
Thank you.
Vice Chair?
No questions.
Mr. Cullen, have you, I'm going to take a step back. You participated as a witness in the CPCN case in 2012. I'm going to forget the case number, 578, whatever it was, the CPCN for the original transfer of Mitchell to Kentucky Power. Is that right?
Yes.
Do you remember taking, I don't know what the right word is, umbrage, taking issue with the fair market value determination or the fair market value calculation used by Kentucky Power in that case?
I don't recall it, I did. I think the proposal on the table was net book value, and I don't recall opposing that.
Okay. Well, I guess it wasn't even fair market value. That going back to the affiliate transaction rules, the lesser of market or net book value. Do you remember taking issue with the market determination?
I don't recall it, I did.
Okay. And I guess what I'm really asking to my question to Mr. Haynes earlier, do you remember if the determination of what the market value was in that matter, whether they used the proposal here, which would be three appraisers and two of them choose the others, and you throw out, at least it sounded like the intent was high and low appraisals of market value. Do you remember that at all in the Mitchell transfer case in 2012?
No, I don't. I don't believe that was testimony or evidence offered in that proceeding.
Okay. And do you remember that proceeding, whether or not Ohio Power Company offered anyone else the Mitchell plant other than Kentucky Power, whether they offered it for sale publicly or put out an RFP to see if anybody was interested in buying it?
There was no RFP.
Okay. So you heard Ms. Keaton's testimony today about the abandonment loss. Is that new information to you, or did you understand that to be the case once there were conflicting decisions between the West Virginia and Kentucky Commission?
Yeah, I was a little bit surprised that she stated in her testimony that my position on that was speculation that the two threshold criteria set forth in the tax code had not been met. Obviously, they have not been met. But if my testimony addressed the situation that if the units both were retired, then Kentucky Power would be eligible for an abandonment loss. And as I responded in response to the company's discovery in this case, under Section 165 of the tax code, an abandonment loss becomes available, A, when there is intent by the party to abandon, which would be the case with an announced retirement of a power plant, and then secondly, when there's action taken to do so. And of course, what we were talking about here, well, first of all, in the CPCN case, there was an assessment of retiring the Mitchell units in 2028 or continuing to operate them to potentially 2040. If they were retired in 2028, both of those criteria would be met as set forth in the tax code. Similarly here, if the units are not retired and in fact Kentucky Power sells its interest in the Mitchell units to Wheeling Power Company, then the abandonment loss will not be available to Kentucky Power. And that was what I just addressed in this testimony, that would be an economic loss to Kentucky Power Company. And if fair market value is used as one component of the buyout price pursuant to the buyout transaction, and let's say, for example, that it's set to zero, then Kentucky Power will never be able to monetize the value of that abandonment loss. And so what I said in my testimony is that at a minimum, Wheeling Power should compensate Kentucky Power Company for that, the loss of the abandonment loss under the retirement scenario.
And I guess what I want to make sure I understand is that because your expectation is, well, is that because you think that Wheeling Power, if they retire the facilities prior to 2040, will have the abandonment loss available to them, available to it? Or is it just merely because of the sale occurring and the retirement not occurring, that's an economic detriment to Kentucky Power's customers?
Well, actually, it's a combination of both. The first thing is that Kentucky Power will never be able to take that abandonment loss, as it will never be able to take the decommissioning costs as a deduction for income tax purposes. And then if indeed the transfer takes place, the sale takes place, then Wheeling Power, when it retires the plant, will take the abandonment loss for 100% of the remaining tax basis, as well as the deduction for the decommissioning costs at that time. So both of those tax benefits will be lost to Kentucky Power. And, and I think that I tied that to the determination of the fair market value as a component of the buyout price, if indeed it was just simply set to zero, which, I think is fairly likely. Then the Kentucky Power and its customers lose forever those two tax benefits. In other words, Kentucky Power would be worse off than just simply retiring its ownership interest in the two Mitchell units if it sold for $0 and paid Wheeling Power for the decommissioning costs and then lost the tax benefits. All in, Kentucky Power would be better off just simply to retire the plant than to go through that exercise.
Shifting gears just for a second, do you remember in the 2021-0000, I'm going to make the request that we not, we're never going to go to 1,000, why do we, anyway. The 00004 CPCN, ELG, CCR, CPCN case, that Mr. Becker, who was one of the primary witnesses in that case, had a bar chart that showed the case 1 versus case 2 with the base case with carbon, the base case no carbon, and low no carbon, the differences by year between 2021 and 2040 of the two different scenarios. Do you remember that by any chance?
I do, yes.
And do you remember that, at least comparing case 1 to case 2, the bar chart indicated that between the horizon between 2021 and 2028, that the costs actually went down prior to 2028? Do you remember that?
I seem to recall that, yes.
And did you hear my questions earlier to Mr. Haynes about the difference between the way you would make investments in a unit that you expect to operate through 2040 versus a unit that you would expect to operate only until 2028?
Yes.
Okay. And is it your understanding that's what that reduction in the bar chart is intended to reflect, that there were different investment decisions between case 1 and case 2 because there are different retirement expectations?
Yes, that's correct.
Okay.
That was explicitly addressed, yes.
That was part of the economic analysis in that case, right?
That's correct, yes.
So are you aware of anything in the provisions that you read or any of the recommendations you have that reflect the differences that are reflected, that were expected between the economics of case 1 and case 2 in regards to these two Mitchell agreements?
No. The only thing that I would note is that the company's provision for depreciation in terms of the assets that are constructed from now through 2028 is allocated between the two parties based upon the remaining ownership life for each entity. So Kentucky Power, if something was put into service in November of 2028, then Kentucky Power would get 1 month of depreciation, and Wheeling Power would get 12 plus 145 months of the depreciation. So in other words, that capital asset would effectively be allocated 1/146th to Kentucky Power and 145 to 146 to Wheeling Power. And so, I mean, that's how they propose to address that issue.
But that would effectively assume that the bars don't go down between 2021 and 2028.
That's correct. That is not explicitly or implicitly addressed. It is not.
I want to ask about the decommissioning costs. If it's transferred at net book value, do you have a particular concern about what Kentucky Power customers have or haven't paid in terminal net salvage up to now being reflected as a deduction or a reduction?
In terms of the buyout price, the accumulated decommissioning that is included in accumulated depreciation would be reflected in the net book value. In other words, that would net essentially into a lower net book value. Then in terms of the payment to Wheeling Power Company, I've addressed that as a separate issue, but I've said that's really uneconomic because the decommissioning cost estimate as of December 31, 2028 would escalate perhaps at 2 to 5% per year all the way through 2040, but the return on the amount, the funds that are paid to Wheeling Power Company would be much greater. In other words, it would be something that Kentucky Power would have to finance, and then Wheeling Power would have the use of those funds because it would displace their financing requirements until they actually have to pay the decommissioning in 2041, 2042, 2043, 2044, 2045. So it's really an uneconomic decision, and it really effectively results in a subsidy by Kentucky Power Company to pay these funds today to Wheeling, or at the time of the sale, to Wheeling Power Company, because Kentucky Power would have to finance it. Think of the situation where the fair market value, if that's what ends up in the ownership agreement, and assuming that the commission approves it, let's say the fair market value is 0. That decommissioning term then is something that is subtracted, meaning that it's not money that Wheeling Power pays to Kentucky Power Company, it's cash that Kentucky Power Company has to pay to Wheeling Power Company. Well, all of a sudden, whatever that amount is, Kentucky Power would have to finance that today, or at the date of the sale, pay it to Wheeling Power Company. Wheeling Power would have those funds, would be able to displace its financing. So, effectively, it's a subsidy then of Wheeling Power Company for the next 15 or 18 years.
And let me ask that differently, just so I understand. You're saying that it would be reflected in the either the net investment rate base or the capitalization of Kentucky Power that would cost customers both the amount plus a weighted average cost of capital on it because they're financing it. It would be escalated, that would be reflected in the present value that's actually provided, and then it will be an offset to rate base for Wheeling Power, and thus a weighted average cost of capital reduction to their rates?
Well,
rates?
Yeah, let's look at it from both utilities' perspectives. Kentucky Power Company would have to finance those decommissioning costs under the scenario that I posited, which is a fair market value of 0. Let's say that the appraisers come up with a negative fair market value, which would be consistent with the Commission's determination in the 2021-00004 proceeding, because in that case, the sunk costs were determined, or the net book value was determined to be as sunk costs. But then going forward, in terms of the operating costs versus new investment versus continuing to operate the Mitchell units, that was a negative, that was a detriment compared to an alternative. And so, in essence, if that economic analysis holds, then the fair market value under an appraisal structure, which is what that was, is negative. So then under the proposed ownership agreement, the fair market value would be set to 0. And then that means that the decommissioning costs would have to be paid by Kentucky Power to Wheeling Power. Kentucky Power would have to borrow those funds. Let's just say, for example, it was $50 million. I don't know what it would be. Let's just assume it's $50 million. Okay, so that's something then that Kentucky Power would have to reflect in its capitalization. It would not necessarily be includable in rate base, but I suspect that the company then would come into the commission and say, could we have authorization to put that $50 million as recorded as a regulatory asset and get it included in rate base, after the sale? And so, I mean, it would definitely impact customer rates, just playing out that scenario. So now the $50 million goes to Wheeling Power Company, and so this is money that they will have available to displace other financing for the next 15 to 18 years until they actually spend money to decommission the site. And so on the one hand, you have Kentucky Power financing this 15 to 18 years before the amounts will actually be spent, and then Wheeling Power gets the benefit of that. And then the other part of your question was on the decommissioning cost escalation. I've heard some arguments today, and I did address this in my testimony, so I'm not offering on the stand rebuttal, but that Kentucky Power doesn't get a benefit from prepaying decommissioning 15 to 18 years into the future, because the escalation of those costs was assumed in the company's last decommissioning study for Mitchell at 2.35%. Okay, so it doesn't make sense to prepay and finance, costs that will not be incurred until 15 to 18 years in the future that have an 8 to 9% gross up cost of capital in order to avoid a 2.35% escalation. Better off to pay it when it's due. It's like a negative arbitrage.
I don't have any additional questions. Thank you, Mr. Cullen. Mr. Kurtz, do you have any redirect?
Thank you, Chairman. Just a little bit. On this, the abandonment loss issue. So what is your estimate of the abandonment loss value to Kentucky Power if they simply retired the plant rather than selling it to Wheeling at 0 fair market value?
I had reflected in my testimony as $28 million, and that was based upon my testimony in the certification case, the 2021-00004 case. And after I'd filed my testimony in that case, I subsequently recalled that the company had corrected a response to a data request, and that when that was worked through the process, it was actually $8 million. And that's consistent with Ms. Keaton's testimony in this case.
Okay, so $8 million is the abandonment loss value?
Yes, on a net present value basis.
Okay. And under the proposed ownership agreement, Kentucky Power would be required to sell at the fair market value under the appraisal process. They would not have an option.
That's right, because the provisions in I call it paragraph 9.6. I don't know if that's technically the legal designation or not, but paragraph 9.6 of the proposed ownership agreement uses the word shall. Unless there's an early retirement event, Kentucky Power shall sell and Wheeling Power shall purchase. It's not an option. The only thing that's optional is if Wheeling Power determines to prematurely retire the units. And that would be considered an early retirement event. In that case, there's no sale, no transfer, the units are retired.
Two aspects of the decommissioning. Let's use the $50 million example, just for an example. If Kentucky Power pays that in 2028 to Wheeling, it would not be able to deduct that for income tax purposes?
That's correct.
So how much of a loss would that be under the example that it's $50 million?
That would be a $10 million loss to Kentucky Power Company and its customers.
Because the federal income tax rate is 21%?
That's correct. Probably a little bit more than 10 million, maybe 11 to 12 million.
Is there a state income tax effect also?
Yes. That's why I said probably a little bit more.
So basically, what percent should we be thinking about?
I think it's 26%, approximately 25.9 or something like that.
Okay. And then the other element of decommissioning you've addressed is the negative arbitrage?
That's right, and I addressed one other aspect of the decommissioning in that the decommissioning allocation was 50-50 as of December 31, 2028, and I argued that that was an excessive allocation to Kentucky Power, and it really should be 41 and 59% to Kentucky Power and Wheeling Power respectively, because Wheeling Power would operate the power plant for potentially another 12 years.
Okay, but let's stick with the negative arbitrage.
Yes.
The only way that it would not be negative arbitrage is if Kentucky Power's weighted average cost of capital, 8 or about 9%.
It's between 8 and 9%, I believe.
If its weighted average cost of capital was lower than the projected escalation cost of decommissioning.
That's correct, because the decommissioning cost pursuant to the ownership agreement is as of December 31, 2028.
Okay. The fair market value to a third-party arm's length purchaser, you were asked questions about that, do you recall?
Yes.
Well, let me go back to one thing. Chairman asked you about Mr. Becker's testimony. You recall that from the 00004 case?
I do, yes.
Was he referring to the glide path to retirement factor that was included as a explicit calculation in each of the financial exhibits of Mr. Becker? I believe it's about $30 million a year.
That was
$30 million total.
That was the evidence in the record, yes.
Okay. So going back to fair market value, a third party, let's just use hedge fund, I know that's kind of pejorative, but so that third party buyer would not take into account jobs and taxes and so forth that were a positive benefit to West Virginia, would it?
No.
Your Honor, I'm going to object. Mr. Kurtz is simply having Mr. Collin read his testimony in the record. This is far beyond any crossing of Mr. Collin.
It's beyond
by the
Mr.
chair
Overstreet.
or by me.
It's beyond Mr. Overstreet's, but it's directly responsive to the chairman's questions.
Yeah, I'm going to sustain the objection.
Okay. Do you recall hearing testimony about the physical hedge value of a power plant?
Yes, I do, from the chairman, yes.
Would Wheeling get a physical hedge value of owning Mitchell that a third-party buyer would not?
Yes, because of the operation of in West Virginia, it's called the ENEC, or the Energy something clause, but it's the equivalent of the fuel adjustment clause in Kentucky. But the way that the ENEC works in West Virginia is that the fuel costs go in, and then any energy revenues also go in, but as a negative into the ENEC. So that's why it operates, or how it operates, as a physical hedge, because if the fuel costs are less than the energy value in the MISO markets, then there's a benefit to customers in...
You meant PJM. You said MISO, you meant PJM.
Oh, I'm sorry, yes, I did mean
In other words,
PJM.
when
yes.
a utility owns a power plant, they get energy at the lower of cost or market.
Correct, yes.
Chairman, those are all my questions.
Sure, do you have any additional questions?
Just a couple, Your Honor. Mr. Collin, under the agreement, the ownership agreement, which was Exhibit 3, I think, to Mr. Madison's testimony.
Yes.
And then the rewrite of section 9.6 that Mr. Haynes discussed, I think it was this morning. There are three options for how a transfer from Kentucky Power to Wheeling could take place. The first option would be a negotiated price. Is that accurate?
Yes, which I think highly unlikely.
But that's a possibility.
That's the first option.
Second option would be the option to split the two units, right?
Well, I don't know what order the company's rewrite of the
A
proposed.
second option would be to split the two units between the two companies.
Yeah,
Is that-
which I believe the AG and KAUC have not had an opportunity to respond to, and I think.
But that's an option, right?
Well, there are many options, but that was one articulated by Mr. Haynes in his rebuttal testimony,
Right.
to which we haven't had any opportunity procedurally to respond to, and we would oppose.
Okay. And then the third option would be the fair market value as calculated by the three appraisers.
As one component of the buyout price, the third option is more extensive than just the fair market value from the three appraisers. There's also the CapEx adjustment, there's the coal inventory adjustment, there's a decommissioning cost. You know, there's
Okay.
multiple factors that go into that buyout price.
Fair enough. But however the transaction were to be structured, it would come back before this commission, would it not, under 278, 218? Because the original.
I'm sorry, I didn't mean to interrupt
No, I
you.
know
I
you did.
caught myself.
I paused.
No,
Because
I thought you were
the
finished, I was going to jump in and.
Because the original value of the Mitchell plan was more than $1 million.
Could you say that again?
Yeah. However the transaction were structured among the three options, it would be brought back before this commission for approval, because the original value of the Mitchell generating station was greater than $1 million. 278, 218.
Greater than the what?
$1 million.
Yes, but what our concern is that first of all, the proposed ownership agreement doesn't provide for the company coming back to the commission except in the negotiated scenario out of the ones that we just discussed. And the other problem is that the ownership agreement says that if it goes to the fair market value approach, it shall be final, binding, and conclusive. And so our concern is that if the commission approves the ownership agreement, there's no recourse then, because, you know, arguably the company could say to the commission, hey, you approved the ownership agreement, and it has this final, binding, and conclusive language in there, and yes, we're back here now, but you can't change the price. You can't change any of the terms or conditions that you agreed to. And that's, I think that's a practical concern. You know, I heard Mr. Haynes' testimony that, yes, they would come back to the commission, you know, if there was a fair market value determination. But, you know, I think that if I could speak for the Attorney General and the KIUC, the concern still exists that if the commission approves the ownership agreement and that language, that, you know, the company would have to acquiesce then in any changes that the commission may want to make, either to the methodology or the outcome.
So you would agree, wouldn't you, Mr. Collin, that Kentucky Power Company cannot strip this commission of its jurisdiction by means of a contract?
I would agree, but I would suggest to you that maybe the company could argue back to the commission, you approved the ownership agreement, it had this language in it, you knew it was in it, and so now you can't disturb the result of the fair market value. I mean, this was a contract, an ownership agreement that you approved, if the commission approves it, and I think at that point, it may limit the commission's ability to actually modify that outcome.
And the commission, if it were to approve the agreement, could make explicit the fact that that language did not bind the commission.
I still would oppose the ownership agreement, but if the commission is inclined to approve it or some version of it, I would encourage the commission to put that language in there.
And Mr. Collin, if the if Wheeling and Kentucky Power, under the revised section 9.6, were to elect to separate the two units, then Kentucky Power would have the ability to retire its unit in 2028 and take your abandonment loss. Is that not true?
If that whole sequence went forward, that's correct. But as I mentioned before, my clients and I, on behalf of my clients, oppose that option. I mean, it would expose the company to significantly more risk. There's no indication that if Wheeling Power Company were the operator, that it would get the same attention, that the Kentucky Power Company designated unit would get the same attention as Unit 2. There's no safeguards. We haven't had a chance to actually look at a real proposal. There is no proposed agreement. This isn't part of the company's application in this proceeding. It's a late-breaking item, and I just think it's, I'm not a lawyer, but I think it's extremely procedurally infirm.
Well, but again, if that were the transaction, the commission, to separate the units, the undivided interest, the commission would weigh in under 278.218.
If that's something that the commission procedurally can consider in this proceeding, I think it would be obvious then that, you know, it'd be something that it could consider.
Nothing further.
Mr. Overstreet, I'm getting worried. I don't know if you have what they joke about being the ESPN or not, but I did have one or two questions about the opportunity of abandonment loss.
I have basic cable, so I don't.
I heard somebody once say, I've got ESPN too, or I've got ESPN, the other guy said, I got ESPN too. I can read people's minds. The abandonment loss being available to the split, which whether it's an option or not, we've not seen any language, so taking that for what it is. But when you talk about the legal triggers in, was it section 165 of the Internal Revenue Code that deals with the abandonment loss, is that right?
Yes, that's correct.
So section 165, that are the same factors, would the same factors be available in the event that the units were split and Kentucky Power owned one unit and retired it December 31st, 2028? Would the same abandonment, would the same triggers be available, or the threshold requirements be available for that abandonment loss in that event?
The same section 165 triggers would apply whether it's one or both units. And in the one case, there would be an actual retirement and then the ability to take the abandonment loss. In the other situation where both the 50% undivided ownership interests in both units are sold to Wheeling Power Company, what our recommendation is that you know, if the fair market value component of the buyout price is set at 0, that Wheeling Power reimburses for the lost value of the abandonment loss. Because there wouldn't be an actual abandonment loss, because now Kentucky Power no longer owns an interest in either of the units.
And going back, I mean, I'll withdraw the question. It's more of a statement on this issue of procedurally with you, Mr. Overstreet. I have more questions than I think that maybe the company is able to answer today on this alternative proposal provided only in rebuttal testimony about splitting the units. which would include, you've received a CPCN for ELG at this point for the entirety of the Mitchell unit. So would the anticipation be that the company would build ELG for both units, and at some point between now and December 31st, 2028, change the ownership from a 50% undivided interest to a sale of 1 and 1? One of them will have ELG, they'll both have ELG compliance. Does Kentucky Power have the ability to buy the ELG assets without a CPC from this commission? I mean, these are the things that I can't ask Mr. Collin, and I don't know that it would be necessarily fair to ask any of your witnesses these questions, because I don't know that, to Mr. Haynes's point, these conversations are still occurring within AEP and Kentucky Power as to what it would actually look like. And so procedurally, I guess I'll let Mr. Kurtz do redirect, but I'll just say procedurally, I'd like to ask a lot of questions right now about this split idea, but I'm in a position where I don't know that it's fruitful to do so.
So, just so I understand, did I understand you to, you may, well, I don't say you misstated, but I thought I heard you say that Kentucky Power received a certificate to perform ELG work.
Wheeling Power did.
Wheeling Power, okay. I'm sorry.
There's a CPCN to do that. Is it for both units? Is it one unit? I presume it's both units, given how I read the West Virginia order or opinion. Could you all buy that without a CPCN for the ELG? I mean, I think you'd have to have well, I don't want to, but it's arguable you'd need a CPCN to even do the transfer from a 50% undivided to a 1 and 1 unit. And so I have questions beyond the tax abandonment laws for Mr. Collin, but it's kind of hard for me to ask those today without a fleshed out proposal. So, Mr. Kurtz, any redirect, Mr. Collin?
No, sir.
Okay. Is there any reason Mr. Collin can't be excused?
And he can be excused.
Okay. Any additional witnesses, Mr. West, Mr. Kurtz?
No.
Okay. And anything else from AGKIUC? Okay. So let's have that conversation for a minute. So we have an application in front of us with proposed changes to the operating agreement and a proposal to seek approval of the ownership agreement. Otherwise, the Mitchell agreement, seek approval of the Mitchell agreement. Both agreements are in front of this commission, and as I understand it, both agreements are in front of the West Virginia Commission. Is that right?
That's my understanding.
Okay. That alternative has been discussed, I'll say it that way, for splitting the units in rebuttal testimony, but we don't have any language. And devil's in the details with this kind of stuff, frankly. I mean, this could be described as selling Kentucky Power's half to Wheeling Power, and then we get down to the devil's in the details. There's a lot of moving parts. So do you have an expectation as to when Kentucky Power will have that proposal in writing, and whether or not it is expected to be in writing prior to the hearing in the West Virginia case, which I understand to be April?
I think the hearing in the West Virginia case is in April, but let me turn and find out.
Well, I say I think it's April because on Thursday's earnings call, there was a map of arrows, and I think April was the West Virginia one. So I believe it's April for the West Virginia Commission's hearing on these agreements. Do you all have an expectation that alternative will be prepared and proposed in that proceeding as an option for the West Virginia Commission?
I don't have an answer to that question this afternoon, Your Honor, but I do have a suggestion to propose that I think might help us to be in a more realistic place to be able to provide more detail. And that is this. We have hearings scheduled this week for 3 days, and since we've wrapped up with all the witnesses at 3:30 the first day, might we propose that we resume tomorrow, maybe, and I don't know if it's a formal conference or if it is in some other format, and have a discussion about the alternative proposal and hear your questions. That might help us to, not holding anyone to anything at this point, but it might help us to provide the commission and the parties with a next document or proposal that fleshes out and addresses the questions, because we'll have the ability to anticipate them. And I feel like given how quickly time is moving and with all of the other things going on, including the 481 docket that's open, it might behoove us to try to work together to identify what are the issues so that we can take those back and make sure that we are addressing all of them.
I think it's for me, hard to really even tell you what the questions are until we see what a firm proposal is and whether or not it's something that the companies are seriously considering. Because I really wouldn't even know where to start without language in front of me.
So I have a preference, and I don't want to speak for the vice chair. I'm choosing my words very wisely here. I don't know that it would be helpful for us to have a proceeding without something in front of us that the company has proposed. With that being said, and Mr. Overstreet and Ms. Glass and I have had this discussion before, and I know you all have briefed this issue in regards to due process, especially in the vein of a commission-initiated investigation, because we do have something in statute that does speak to that time period between an ordering a hearing and the hearing. But I think that, given that we've been gifted 2 days, that I think that I have a preference with the company, if they're going to propose something that alters their application, that you all do so in writing, whether it's with pre-filed direct testimony or not, even if it's just something in writing, giving the commission and the other parties an opportunity to review it. And my preference would be to have another hearing, whether it's virtual or in person, and conduct, in-person testimony, and giving the opportunity for interveners to provide in-person direct and rebuttal testimony, that we can ask those types of questions once something is put in writing. But I'm not necessarily personally interested in sort of dictating in the form of a question what I think something should look like in order for everybody to go back and try to draft it according to around what the questions I had. I don't want the fact that I'm asking questions to even be any indication that I would vote in favor of it or interested in it, but it's in the rebuttal testimony. It's part of the record, whether it's in the application or not. It's part of the company's proposal, but you can tell that we have some pretty detailed questions about the current operating agreement and the ownership agreement, and I just don't think that we're in a position to be able to ask the types of questions we would with what this third road or third way might be. So I know, Mr. Overstreet, you all have filed something to the effect of requesting, let's call it 3 weeks, 3.5 weeks heads up for a hearing. But if you all do want the commission to seriously consider an alternative proposal that's outside of the application, I think we'd probably need a little more leeway on the amount of time between when something like that is put on the record versus when we would have an opportunity to conduct a hearing on that proposal, if that's something you're interested in. I don't.
By leeway, you mean less time.
Less time, and I'll be also very frank. I think the commission would entertain a motion or petition to not do public notice for an additional hearing on the depth of these legal documents. I don't think that we're going to have very many people calling in and giving us much public comment on their perspective on Article 7 of the operating agreement. So, given the cost of publication of notice, and we'll take it under advisement if you all would like to have a hearing on shorter notice, as long as all the parties are able to participate, than the 2 or 3 weeks or even 4 weeks that have been previously required.
And how does the company initiate that or not initiate that?
We'll probably keep the train moving in the direction that it's going unless we hear something else from the company. But I think the timing at this point is whether there's something written on paper that can be submitted that would even facilitate the need for a hearing.
Gotcha.
We were asked, I think, in this case, to have an order by March 7th. I'm going from memory
I
here.
think it may have been before that.
It was like February 17th.
February 7th. I remember a 7 so that's all.
Yeah.
So
So
we've already
it's not
passed
as
that.
it's not as if, and then like they say, you don't have to be faster than a bear, you just have to be faster than the slowest person. The West Virginia Commission has given us an opportunity that they have a hearing in April, so anything that's quicker than them would be, it does seem like we maybe have a couple of weeks to play with, at least one or two. So I throw that out there as consideration to the parties. If you all like to have a discussion with that, or if you all think you're in a place that you all will have pen to paper in a reasonable amount of time. But I don't think that we have an interest in sort of snowballing ideas at an informal or a formal conference or a hearing later this week.
All right, well, thank you, that's helpful, and we'll confer and allow inform the commission and the parties and staff.
Yeah, hearing nothing from the companies or the parties otherwise, I think that we'll continue on the path that we are by getting an order out in a reasonable amount of time. Certainly before the West Virginia Commission at this rate, so we seem to be going faster than they are.
So we have the post-hearing data request.
What I was about to talk about.
And,
Yep.
and then what about briefing?
Give you all the opportunity in the world to file briefs. Would you all like to file an initial brief with responsive briefing by the interveners? Or would you like to have simultaneous initial briefs with simultaneous response briefs?
I think we'd like to have the last word since we have the burden of proof, however that works.
Here's the question, though. If we're going to move into potentially another phase, with the third option, does it make sense to brief?
So that is the other moving part. So today we'll talk about post-hearing discovery and response to post-hearing discovery. My expectation is that you all know by the time discovery ends, whether you all have post-hearing discovery, questions we had today that we need answers to anyways. You'll know during that time period what your all's preference would be, whether you're going to propose or amend the application in the event that you all have a third way before the briefing. But I think once the briefing begins, I think that train has left the station.
That makes sense.
Okay.
That makes sense.
All right. Does that address your concerns?
Yes,
Mr.
it
Kurtz?
does.
Okay.
Thank you.
We had written something down here to that. So we think that we can have, well, let me first ask, does the AGKIUC, did you all have any post-hearing data requests?
Just one on the estimated decommissioning cost.
Okay. So, staff, Ms. Vinsel, you think you could have the post-hearing data requests issued by when?
At the latest, Friday, March 4th.
Friday, March 4th. Okay. So with the exception,
I'm sorry.
no, it's okay. Take your time.
I'm sorry, you go ahead.
Okay. If the data requests can be issued by March 4th, the one from the AGKIUC and the remainder from staff can be issued on March 4th. Other than, and we'll always entertain a motion, so with that being the case, and understanding sort of the quest I've put Mr. Cash on, do you think that the company would be able to respond to those data requests by the 16th?
Yes, Your Honor, with the possible exception of the question to Mr. Cash.
Okay. So that then gives you 2 weeks from tomorrow effectively to make the decision as to whether or not you are going to ask for further proceedings?
That would be my math, but let me turn to my counsel.
At the risk of delaying this unnecessarily, can we take a very brief break that would let them have the opportunity
Yeah, that may be
discuss?
helpful to move things along. So let's just take, 10 minutes would be fine for you?
I think that.
So let's take a short recess till 3:55.
Thank you, Your Honor.
We're back on the record in case, we're back on the record in case number 2021-00421. What we've discussed at this point as a post-hearing procedural process is post-hearing data requests being issued or being tendered by commission staff and the AGKIUC on the 4th of March, and to be responded to by Kentucky Power on the 16th, with an understanding that if Mr. Cash needs additional time on the terminal net salvage value, and interim salvage value calculations, that will take under serious consideration a request for additional time. Then we were going to talk about a briefing schedule, and the reason we went onto the break was to give Kentucky Power an opportunity to discuss, because the end of that discovery would effectively foreclose on an opportunity by the company if they wanted to tender any amendment to the application in regards to this third way of splitting the undivided interest to effectively a divided interest between units. So, Mr. Overstreet, do you have anything on that front at all?
Yes, I do, Your Honor. What we would propose, and I think this is in accordance with what you identified, is that we will be back to the commission one way or the other with respect to the third alternative. And at that point, we could, depending on what that, what that is, then we could proceed with either a further hearing, some sort of conference, briefing, however the commission would want to go.
Do you have an expected date? I mean, if you know it's going to be tomorrow, that's fine. If you know it's going to be Friday, that's fine. But if you expect it to be a week or 2 weeks, just sort of some idea about pen to paper.
I do not have an expected date.
Okay.
Except that it will be done as quickly as possible.
Okay. So before we get to take that into account, let's talk about briefs in the event that we don't get something that the company says, forget it, we threw it out in rebuttal, but we're not interested in putting it on paper. You'll know what the data requests are well in advance of the 16th of actually filing them, and want to give you the opportunity to have the initial brief and the reply brief for the last word. The 16th is a Wednesday. Would you be able to have a brief the 21st?
This is on the assumption that we are not moving to another phase of the proceeding.
That you don't amend the application, essentially.
That post-hearing data request responses are the close of the record.
Yes, the 21st is fine, Your Honor, I think.
And how about response briefs on the 28th?
That is pretty tight, because we're not really going to start the briefing, I'm sure, until the 16th passes.
Yep.
So we know whether we need to brief. We would certainly like 2 weeks instead of 1.
So here's where I am on that, just so you can understand my thinking. You aren't going to be working on the brief on the 28th or the 29th, because that is scheduled to be the hearing in the Kentucky Power Liberty transfer case.
Which actually is all the more reason why.
I just assumed you'll work to the deadline and then you'll be free the whole next week. But let me ask this, how about the 31st?
That's the same kind of problem. I mean,
Or the 1st? Sorry, I thought the 31st was Friday. The 1st is Friday.
April 4th would be better if we're going to, just the weekend.
Get a hearing on the 31st as well.
I would say Mr. West, join the club. I have all these hearings, I think, so does Ms. Vinsel. Okay, well, never mind.
No,
I have-
they are all with me, but
I got you. You got to delegate these days. So April the 4th. how many days would you all need to file a reply to the company?
Uh, 7 days, would that be okay? That'd be the 11th.
That'd be fine. Honesty is the best policy. You all are the one that wanted the order by February the 17th. So if you all would like the 7 days, I'm happy to give you the 7 days, but we're trying to, in the best of our abilities with the resources that we have, accommodate the time periods that are requested. That doesn't really usually give us much in the way of anything. But if you all need 7 days, we're happy to give it to you. So the 11th of April.
11th of April?
Yes, Your Honor, I think if the KAUC and EG are filing their brief on Monday the 4th, which I understand the reason, their rationale for requesting that date, I don't think we'd be pushing it to file something on the 8th. That's really only 2 working days in the day review. So we're requesting.
Okay. So assuming, just so that we have it, assuming we don't get anything back on this third way, I don't know.
It's really new wave.
What it really reminds me of is I think it's not Bing Crosby. Who is it? My Way. Anyways,
Frank Sinatra.
No, he's got the movie, but they're Going My Way. There's an old
Bing
movie.
Crosby.
It is Bing Crosby. Isn't it? Going My Way, where he's Father
Sounds like some
O'Malley
creepy
or
cult to me, I don't know.
third way.
You're way too young to know.
Father O. Okay, it'll come to me. It's definitely Bing though. So assuming you all don't come back with anything on that front, post-hearing data request filed March 4th with post-hearing data request responses on the 16th of March, opening brief by the company on March 21st, a response brief by the interveners on April 4th, and a reply brief on April 11th with the case submitted at 12:01 on the 12th. Is that okay? Okay, Mr. Overstreet?
That's it, Your
Okay, and just so that we're clear, I think what we're probably gonna put in a post-hearing procedural schedule that goes out today on these topics is that that if the company anticipates filing something on this additional path, that it will do so in advance of the March 16th time, the March 16th deadline for post-hearing data requests.
That was my understanding
Okay.
of what I corrected.
I think what we'll also put in the post-hearing procedural schedule, but it'd be better to talk about it now. My preference would be that if you're gonna file that before the 16th, that you do either both or one of the following. That you indicate your availability for a informal conference to discuss scheduling, or you propose the informal conference date, but also what would be preferable is your availability for hearings over the next couple of weeks on this subject.
Certainly.
Okay.
Certainly.
And I know it may not be preferential, but I'm taking a real risk here saying this, so just watch out, everybody. But at least on my calendar right now, Wednesday, March the 30th is open, at least in terms of, there's not a hearing scheduled in this room. Now, that would be the day after what the transfer case is proposed as, but, I mean, they usually give you a deal if you stay 3 nights somewhere, so, maybe we can make it cheaper for everybody that stay here an additional night. But I just want to throw that out there. If you are going to file something, it may be good for you all to go ahead and put out there what your availability or proposals are in terms of a hearing or an informal conference.
That makes sense.
So that there's not as much back and forth. And that way, it'll at least, to your point about setting things off, it'll give an opportunity for the interveners and staff to be able to provide feedback on availability and interest in process moving forward. And to be frank, I just want to cover something that Ms. Blinn mentioned earlier. I don't think we don't have a problem with formal conferences. We just, not in the sense of, let's all sit down and create a horseback committee, and, because I don't think that's.
It shouldn't be our role.
I understand, Your Honor. I apologize that my comments give you that impression, so I was just thinking out loud that it might be helpful to have the feedback, included anything to help with those questions.
And I don't,
I appreciate your perspective and understand it.
what I want to, the reason I mentioned is because I don't want it to seem like, for the purposes of what your all's proposal is, if you file something prior to the 16th, that a formal conference shouldn't be something that's off the table if the language is available as the next, in lieu of a hearing or in addition to hearing or whatever it may be.
Thank you, Your Honor.
Thank you, Mr. Chairman.
Ms. Glass, Mr. Overstreet, is there anything else that we need to?
Not at this time. I think
Mr. Kurtz?
Yes, sir.
Mr. West? All right. Hearing nothing else, Ms. Vinsel, is there anything else we need to? Oh, I know what it was. I just want to remind, please make sure that before the end of the week that we get that affidavit from Mr. Bond. I don't know if he'll be around a notary, and if you need additional time, that's fine to ask additional time, but notarized affidavit just indicating that that was him that provided testimony and that he, I'm happy to give you the oath that we give, the affirmation that we give about the truth of the testimony. But if you all would follow up filing that in the record, that would be preferable.
I think Mr. Bletzecker did something similar in the IRP case.
That's who it was. That's exactly who it was. I knew we'd done it before, but time doesn't matter anymore. COVID is just, it's.
Between
it's-
COVID and the baby time.
And,
it's
yeah,
lost
I don't
all-
even know, the other thing, I just thought of it, I've just forgotten it.
The hearing exhibit?
Yeah, the hearing exhibit, thank you.
Ms. Glass sent me an email to remind me to do it.
Okay, so if you will, just send an email with the link, would be great, of Mr. Cash's rebuttal testimony in the 2017 Ray case to Ms. Vinsel, copying Mr. Kurtz and Mr. West, that we'll make sure the court reporter gets it, includes it as that hearing exhibit 3.
Thank you.
Or 2,
Certainly do.
company hearing
2,
exhibit 2.
it is 2.
All right, thank you all very much.
Thank
This
you.
hearing is adjourned.
Are you a new father?